Rule 6, kinds of pleadings. Okay, Section 1 was not changed at all. Pleadings defined, and pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Walang pagbabago dyan. Ngayon, look at your Section 2. Pleadings allowed. The claims of a party are asserted in a complaint, counterclaim, cross-claim, third-party complaint, or complaint and intervention. The defenses of a party are alleged in the answer to the pleading asserting a claim. An answer may be responded to by a reply only if the defending party attaches an actionable document to the reply. Okay. So very clear from Section 2 of Rule 6. Reply is only required when the answer is founded on an actionable document. Ngayon, bakit kayo magpa-file ng reply? Because the answer is founded on an actionable document and you want to deny the due execution and authenticity of that actionable document. So you only file a reply, as I said, if you want to deny the due execution and authenticity of an actionable document which was attached to the answer. And what is an actionable document? It is a written instrument or document on which an action or defense is founded. It may be pleaded two ways. Number one, by setting forth the substance of such document in the pleading, and you attach the document thereto. Number two, by setting forth said document verbatim in the pleading, kinopya lahat. But napaka-klaro dito sa Section 2, Rule 6. Now, by express provision of law, the actionable document should be attached to the answer. Okay. Ang tanong nga dyan, okay, kinopya mo pero hindi mo inattach sa answer. Hindi na ba yan mako-consider na actionable document? Now, if I go by the provision of the law, for it to be considered an actionable document, it must be pleaded in the manner which I stated earlier, and it must be attached to the answer. Okay. Complaint. The complaint is the pleading alleging the plaintiffs or claiming parties' cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. Ano ang pinakabago lang dito sa Section 3? Yung phrase or claiming parties, or claiming parties' cause of action. And I think the claiming party here, and it's a good actually addition, so that it may refer to a third-party complainant or the defendant in relation to his permissive counterclaim. Answer, Section 4, walang pagbabago. Okay. Now listen carefully to Section 5, and I will read it. Okay. Defenses may either be negative or affirmative. A negative defense is the specific denial of the material fact or facts alleged to the pleading of the claimant essential to his or her causes of action. An affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. The affirmative defenses include fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Affirmative defenses may also include, for the dismissal of a complaint specifically, that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by prior judgment. Okay. Now, an answer, therefore, may raise the following. A negative defense, which consists in defendant's specific denial of the material fact that the plaintiff alleges in his complaint. Okay. And we know that there are three modes of denying. The first one is the defendant must specify each material allegation of the fact, the truth of which he does not admit, and whenever practicable, set forth the substance of the matters on which he will rely to support his denial. So lalabas yan sa answer. Defendant specifically denies the allegations contained in paragraph 2 of the complaint, the truth of the matter being that. Kailangan yung sabihin yung rason. Kasi kung wala yung rason, ang miski ka nag-specific denial, deemed admitted yan. Pangalawang pamamaraan, when the defendant is without knowledge and information sufficient to form a belief as to the truth of a material averment made in the complaint. he shall so state, and they shall have the effect of a denial. Example, I specifically deny the allegations contained in paragraph 2 of the complaint, the truth, for lack of information sufficient to form a belief as to the truth and falsity thereof. Okay. Maaari din naman partial denial, partial admission. Under the 1997 Rules of Court, notice that the ground mentioned now, the grounds in Rule 16 of the 1997, yung grounds for purposes of filing a motion to dismiss, kung natatandaan nyo yung Rule 16. Okay. Yan can be pleaded also as an affirmative defense. Now, under the 2019 rules, wala na tayong Rule 16. Totally na-delete na yan. Wala na, totally na-repeal. Okay. Yung grounds ngayon ng Rule 16, okay, may now be raised, okay, as and by way of affirmative defense. So ang mangyayari dyan sa imagine your complaint, the answer. Ang lalamanin ng answer nyo, ano? First, your admissions, then your specific denials, okay? And then your affirmative defenses, okay? Or affirmative defenses, which can be your grounds, which are the grounds raised in the former Rule 16. Now, with the repeal of the entire Rule 16, therefore, all the grounds enumerated in the former Rule 16 may now be raised as affirmative defenses in the answer. At ano-ano yon? Number one, that the court has no jurisdiction over the person of the defending party, that the court has no jurisdiction over the subject matter of the claim. 3, the venue is improperly to sue. 3, that there litis pendentia. 4, res judicata. Then, the pleading asserting the claim states no cause of action. The claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. The claim on which the action is founded is enforceable under the provisions of the statute of frauds, and that the pleading precedent for the claim has not been complied with. Okay. Yung mga grounds na yan, dapat erase nyo yan sa answer by way of affirmative defenses kasi wala nang Rule 16. Pero sa grounds na yan, may 4 na pwede kang mag-file ng motion to dismiss. Okay. Which is pursuant to Section 1 of Rule 15 of the 2019 amendments. Okay. So, ano yung mga grounds na yon? Lack of jurisdiction over the subject matter, litis pendentia, res judicata, okay, and prescription. Now, in other words, okay, with the repeal of Rule 16, all those grounds mentioned are under Rule 16 pleaded by way of affirmative defense, which you will put in your answer. A motion to dismiss can only be filed now, come May, no? Under the 2019 rules, okay? Pwede lang kayo mag-file ng motion to dismiss on 4 grounds. Lack of jurisdiction, okay, over the subject matter, litis pendentia, res judicata, and prescription. Is that clear? Okay. In fact, if we go later to Section 1 of Rule 9, the court on its own can dismiss a complaint when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter on the ground of litis pendentia, on the ground of res judicata, and then litis pendentia and statute of limitations. That is pursuant to Section 1, Rule 9 of the 2019 rules. Okay, now, let's now go to Section 7. Okay, Section 7. Actually, the Section 7 of the 2019 rules, hindi naman masyadong inamend. Okay? Merong amendment lang sa bandang dulo. Okay? Which is consistent with jurisprudence. Let's read Section 7. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim, okay, and does not require for its adjudication, the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that an original action from the RTC, the counterclaim may be considered compulsory regardless of the amount. At ito na yung amendment. A compulsory counterclaim not raised in the same action is barred unless otherwise allowed by the rules, which is consistent with jurisprudence. Okay, now, so what is made clear under the amendment is that a compulsory counterclaim not raised in the same action is barred. You cannot file a separate independent action on that. Okay. So what is a counterclaim? As defined under Section 6, Rule 6 of the 2019 rules, okay, as it is any claim which a defending party may have against an opposing party. They are generally allowed in order to avoid multiplicity of suits and to facilitate the disposition of the whole controversy in a single action, such that the defendant's demand may be adjudged by a counterclaim rather than by an independent suit. And what are the limitations, okay, para ka mag-raise ng counterclaim? Number one, the court should have jurisdiction over the subject matter of the counterclaim. Number two, that it could acquire jurisdiction over third parties whose presence is essential for its jurisdiction. And that is based on the ruling of Lafarge Cement Philippines versus Continental Cement. Okay. Paano mo ngayon malalaman? Okay, so there are two kinds of counterclaims, di ba? Isang counterclaim na compulsory, isang counterclaim na permissive. Now, ang tanong, paano mo malalaman kung yung counterclaim na nire-raise mo sa iyong answer permissive o counter or compulsory? Ask yourself these questions. Okay. And if the answer to all these questions, lahat yan yes, okay, then you know that your counterclaim is a compulsory counterclaim. So una, ano ba yung mga questions na yan? Okay. Based on the case of Bungkayaw versus Fort Ilocania, first question, are issues of fact and law raised by the claim and by the counterclaim largely the same? Second question, would res judicata bar a subsequent suit or defendant's claim absent the compulsory counterclaim? Ito yung pinaka mas logical na tanong. No? Will substantially the same evidence support or refute plaintiff's claim as well as defendant's counterclaim? At ito yung pinaka-importante sa lahat. Is there any logical connection or relations between the claim and the counterclaim? A positive answer to all these questions would indicate, therefore, that the compulsory counterclaim is that the counterclaim is compulsory. Unang-una, bakit ba natin kailangan na magkaroon na malaman ang distinction kung ang ating counterclaim ay compulsory o hindi? Unang-una, okay, kaya natin dapat malaman kung compulsory or hindi or permissive yung counterclaim natin. Pagka compulsory, hindi na kailangan sa answer nyo magkaroon kayo ng certificate of non-forum shopping. Pero pag ang nire-raise nyo permissive counterclaim, then it is a must that your answer with permissive counterclaim must contain a certificate of non-forum shopping. Why? Because a permissive counterclaim is considered an initiatory pleading. Number two, sa compulsory counterclaim, okay, because of the suspension of OCA Circular Number 96-2009, okay, where it clarified that the filing fee on the compulsory counterclaim has been suspended, hindi tayo magbabayad ng filing fee on the compulsory counterclaim. Pero ang permissive counterclaim, magbabayad tayo ng docket fees dyan, okay? Kundi the court will not be able to acquire jurisdiction on your permissive counterclaim, lalong-lalo na, okay, syempre kung talagang hindi mo pagbayad because it's intentional and deliberate, then the ruling in Manchester will now be followed. But of course, if it's unintentional, nagkulang lang yung bayad mo, hindi ka agad dyan i-dismiss. Ang mag-a-apply ngayon dyan is yung Sun Life Assurance. Okay. Now, pangatlo, okay, When you speak of compulsory counterclaim, you have to raise it. Because if you don't raise that compulsory counterclaim, tulad ng nabanggit natin kanina, deemed barred. Hindi ka pwedeng mag-file ng panibagong kaso, tapos yung subject matter ng kaso mo ay yung dapat ni-raise mo by way of compulsory counterclaim. Eh, ang permissive counterclaim, miski hindi mo ni-raise yan dun sa asunto na yon, you can file a separate action. Okay? Clear, ha? Okay, now, the rule in permissive counterclaims is that for the trial court to acquire jurisdiction, the counterclaimant is bound to pay the prescribed docket fees. Since the petitioner in the case of GSIAS versus heirs of Caballero did not pay the docket fees, the RTC did not acquire jurisdiction over its permissive counterclaim. Okay. Section 9, yung counterclaims and cross-claims, walang pagbabago. Okay. Ito medyo may pagbabago, okay? And I just would like to greet, okay, para naman ako nasa radyo, okay, our Commissioner Jojo Soreda T, who's a Commissioner of the Legal Education Board. Mas lalo akong kinabahan. Anyway, okay. Section 10, ito ang malaking pagbabago din. All new matters alleged in the answer are deemed controverted. So pag file mo ng complaint, nag-file ka na answer, deemed controverted, pinagtatalunan. Okay. Kaya hindi ka na dapat mag-file ng reply. But if the plaintiff wishes to interpose any claims arising out of the new matters so alleged in the answer, such claims shall set forth in an amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. A reply is a pleading, the office or function of which is to deny or allege facts in denial or avoidance of new matters alleged in or relating to said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. So anong ibig sabihin ng pagbabago sa Section 9? Complaint, answer. Kung ang answer hindi naman founded, if the defenses in the answer, okay, are not founded on an actionable document, and you want now to, and the plaintiff wants to controvert new matters in the answer, hindi reply ang ipafile. Ang ipafile mo, it's either i-amend mo yung complaint mo or you file a supplemental complaint. Ngayon, kung wala namang new matters na ni-raise, ang katapusan ng pleading nyo hanggang answer lang. Now, however, if the answer is founded on an actionable document and the plaintiff would like to deny the due execution and authenticity of the said document which was attached to the answer, then the plaintiff can file a reply. If a reply is founded on an actionable document, yan, the defendant, okay, can file now a rejoinder to deny the due execution and authenticity of an actionable document that was attached to the reply. Okay. So kung makikita nyo, iniigsian, yung binabawasan o hindi pwede kami kahit anong pleading, basta file ka lang ng file. Ngayon, may rason bakit ka nagpa-file. Okay? Now, look at your Section 11. A third fourth party complaint is a claim that a defending party may, with leave of court, file against a person not a party to the action called the third fourth party defendant for contribution, indemnity, subrogation, or any other relief in respect of his or her opponent's claim. I call that CISO. Contribution, indemnification, okay, subrogation, or other relief in respect of his or her opponent's claim. The third-party complaint shall be denied admission, okay, and the court shall require the defendant to institute a separate action where a third, fourth-party defendant cannot be located within 30 calendar days from the grant of such leave. Matters extraneous to the issue, or B, matters extraneous to the issue in the principal case are raised, or C, the effect would be to introduce a new and separate controversy into the action. It is very clear, therefore, for the amendment, okay, from the amendments, okay, na may grounds na for for the court to deny, okay, a motion to admit third-party complaint. But let me first stress that the admission of a third-party complaint lies with the sound discretion of the court. If leave to file a third-party complaint is denied, the proper remedy is to file a separate case, not to insist on the admission of a third-party complaint all the way up to the Supreme Court. And that is the ruling in the case of DBP versus Clarges Realty Corp, GR number 170060. Now, notice that the order granting the motion to admit third-party complaint, okay? Nag-file ako ng motion to admit third-party complaint, granted. But based on the amendment, it would appear that even if it was granted, the court may recall the order granting it if the defendant, okay, if the defendant to the third-party defendant cannot be located within 30 calendar days from the grant of such leave. Okay. Anong ibig sabihin cannot be located, okay, within 30 calendar days from the grant of such leave? That's it. Okay. Ibig sabihin hindi siguro ma-serve yung summons. So, nung binabasa ko to, at saka yung Rule 14 sa summons, naisip ko, o sige, kunwari, so the defendant cannot be found. Okay, his whereabouts are unknown. Pero dun sa Rule 14, Section 16 ng panibagong rules. Okay? Rule 14, Section 16 ng panibagong rules. Nakalagay dun, okay, nakalagay na if the whereabouts of the defendant is unknown, you can serve summons by publication. Okay? In any action for that matter. And I'm referring to Section 16, Rule 14, service upon defendant whose identity or whereabouts are unknown. Okay. So I'm trying to reconcile these two provisions. Kasi sabi dito nga sa Section 11, okay, the third party complaint shall be denied admission, and the court shall require the defendant to institute a separate action where A, the third-party defendant cannot be located within 30 calendar days from the grant of such leave. So I filed a motion to admit third-party complaint, granted. Summons now was trying to be served, okay, on the third-party defendant. But the third-party defendant within a period of 30 days cannot be located. What will now happen? The court now can recall the order granting the third-party complaint. Okay. But my question in my mind, and I said I do not want to venture a wild guess, and I would rather wait for the Supreme Court to issue a ruling on this matter when the proper time comes. Does it mean, therefore, that we cannot avail, the third-party plaintiff cannot avail of Section 16, Rule 14, okay, of the 2019 Rules of Court, where in the said provision it provides if the defendant's whereabouts are unknown, one can ask the court and ask permission that the summons be served through publication. Okay, now there are other grounds on which a motion to admit a third-party complaint can be denied. Matters extraneous to the issue in the principal case are raised, or the effect would be to introduce a new and separate controversy into the action. As I said, in the case of DBP, if your motion to admit third-party complaint is denied, you don't insist that it should go up to the Supreme Court. The remedy is to just file an independent, separate action. Okay. Now, for those who are students, maybe it would be nice to know what are the requisites for, or remember or recall, what are the requisites for a third-party action? Number one, that the party to be impleaded is not yet a party to the action. Number two, that the claim against the third-party defendant must belong to the original defendant. Number three, the claim of the original defendant against the third-party defendant must be based on plaintiff's claim against the original defendant. Pinapasa niya kasi doon sa third-party defendant. Number four, the defendant in the main case is attempting to transfer the third-party defendant the liability asserted against him by the original plaintiff. Now, and that is the case of Philtranco Service Enterprises versus Paras. Okay. Section 12, bringing new parties, wala naman tayong pagbabago dyan. At yung Section 13, wala naman except katulad nga na nabanggit ko sa inyo, the change referred to gender inclusiveness only, meaning his or her na, hindi puros his lang. Okay? Now, Rule 7. Okay. Okay, in Rule 7, okay, if you have your matrix with you or your rules of court, Sections 1, caption of the pleading, 2, Section 2, the body, okay, Section 2, 1 and 2, no changes, okay, still the same provisions. Now, let's go to Section 3, kasi ito, substantive ang change, okay. Section 3, signature and address. Okay. Let me just read the provision first, then we go on to the comments. Every pleading and other written submissions to the court must be signed by the party or counsel representing him or her. The signature of counsel constitutes a certificate, okay, by him or her that he or she has read the pleading and document. That to the best of his or her knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, A, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. B, the claims or defenses and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. C, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under the rules. And number 5, okay, the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on belief or lack of information. And this is very important. The rules further provide that if the court determines on motion or motu proprio on its own, and after notice and hearing that this rule has been violated, it may impose an appropriate sanction or refer such violation to proper office for disciplinary action on any attorney, law firm, or any party that violated the rule or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. The sanction may include but shall not be limited to non-monetary directive or sanction, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of part or all of the reasonable attorney's fees and other expenses, okay, directly resulting from the violation, including attorney's fees, okay, for the filing of the motion for sanction. The lawyer or law firm cannot pass on the monetary penalty on the client. Okay. Okay, this one is really very earth-shaking, especially for the lawyers and practitioners. Okay. You know, when a lawyer affixes his signature on a pleading, in effect, okay, based on the rules, he guarantees the following. He certifies that the following. Number 1, that he has read the pleading in the document. Number 2, to the best of his knowledge or information and belief, which information and belief was formed after an inquiry reasonable under the circumstances. But what is inquiry reasonable under the circumstances? Hindi yan dinefine ng rules. Okay. If he affixes his signature on the pleading, the lawyer further certifies that it is not being presented for any improper purpose such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. He further certifies that the claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. Kumbaga sinasabi niya talaga itong final kong kaso o itong answer na final ko, talagang ito, kumbaga it's based on law. Hindi ito parang contrived or kathang-isip lamang. Now, and this is also important, the lawyer, when he affixes his signature, the factual contentions have evidentiary support. Hindi na pwedeng attitude bahala na si Batman. Okay? The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under these suits. And the denials of such factual contentions are likewise warranted by evidence, or if so specifically so identified and reasonably based on belief or lack of information. Okay. Yaan ang kumbaga ginagarantihan pag ikaw, abogado, pinirmahan mo yung pleading. Ibig sabihin, lahat ng sinasabi mo sa korte, katotohanan lamang at merong evidentiary support. At ito ay, it can be, and it's likewise legal, it's based on law. As I said, hindi yung basta bahala na lang mag-file ng kaso, tapos hayaan mo na pagka magta-trial sa ako, maghahanap ng ebidensya. You don't do that. Okay, now, in fact, if the court determines on its own, or upon motion of the other party, of course, there's going to be notice and hearing, that the above rule has been violated, nalaman na pangharas lamang pala ito, what can happen? The court may impose an appropriate sanction or refer such violation to the proper office for disciplinary action on any attorney, law firm, or party that violated the rule or is responsible for the violation. Naku, baka ma-disbar pa yan. Okay? That would be agad kasi proper sanction. So anong pwedeng mangyari? Mag-complain ka na itong abogadong to ay nagdidemanda na wala palang ebidensya. Okay? Number 2, absent exceptional circumstances, and this to my mind is really very, how would I put it, very scary, A law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. So anong ibig sabihin yan? If you are in a law office, hindi na lang pwedeng sasabihin ng partner, o sige, bahala ka na dyan, associate, bahala ka na, ikaw nang bahala dyan. They really have to work together because if the associate falters, okay, and then knowingly filed a case na wala palang ebidensya, pati yung partner sabit. Okay. The sanction may include but shall not be limited to non-monetary directive or sanction, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing payment to the movant of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of the sanction. Imagine the lawyer will be paying fees, okay, by way of sanction, okay. And the lawyer or law firm cannot pass on the monetary penalty to the client. That's how serious this is. Kung ma-impose ka ng sanction, okay, at pinagbayad ka ng court, let's say, ng 5,000 pesos, yung 5,000 pesos manggagaling yan sa bulsa ng abogado, hindi pwede yung singilin sa kabila. Okay. Now, I will share this because this is just my personal observation. I hope you don't mind me sharing with you the personal observation. When you're a lawyer, of course, there's parang lahat naman ng abogado, yung mga sinusulat, base yan sa kwento. Okay? Base yan sa representation ng client. Okay? Dapat sana siguro nagkaroon ng agreement. And this to my mind, the rules of court, the proposals, will have a change. There will be a paradigm shift in the lawyer-client relationship. Why? Because syempre, I don't want to be sued for this, di ba? So syempre, pag nag-usap kami ng kliyente, papipirmahan ko na lahat ng sinasabi mo sa akin, pawang katotohanan lamang. At lahat ng binibigay mo sa akin ebidensya ay pawang katotohanan lamang. Para meron akong depensa na hindi ako pumunta sa korte tapos yung pala ay sued lang on the basis of wild imagination. Okay? I think there should be an agreement between the lawyer and the client so that the lawyer naman can protect himself. Okay? Now, notice in Section 3B, okay, of Rule 7, it is incumbent upon the lawyer to verify the representations of the client. But as I said earlier, okay, ano ba yung definition ng inquiry reasonable under the circumstances? Yan hindi pa na-define ng court. Now, the pleading, if also I will discuss this again in another rule. But here, sinabi na that the pleading is no longer based on ultimate facts, but on evidentiary facts. Okay, now, very important yan. Okay? Lalo na pagka nagkuha tayo ng bar at sinabing gumawa ng complaint. Okay? And I will discuss that later. Now, let me go now to verification. Okay? Except when otherwise specifically required by law or rule, pleadings need not be verified under oath. A pleading is verified by an affidavit of an affiant duly authorized to sign said verification. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or special power of attorney, should be attached to the pleading and shall allege the following. That specific provision in the 2019 proposal, very clear that if the person who's going to verify is not, let's say, the plaintiff or the defendant, okay, and the pleading has to be verified, the authority of the person to verify the said document should now form part of the pleading to be verified. Yung SPA o yung SecCert or yung director certificate kung korporasyon yung defendant or yung plaintiff. At paano mag-verify? Okay. Under the old rules, okay? Under the old rules. I don't want to call it pala old. Kasi current pa rin ngayon yan eh. This new 2019 rules will take effect in May. So technically, hindi pa siya old. The current rules, okay? Paano ba tayo mag-verify? Okay, di ba sa verification, ang nilalagay natin, number one, I'm the plaintiff in the form of caption case. I have read the contents of the complaint, and they are true based on my own personal knowledge or based on authentic documents. Diba? That they're correct and ganyan. Okay. Ang verification ngayon, ang verification come May will be different. Bakit? Because under Section 4 of Rule 7, 2019, there are additional attestations that must be included. Okay. Thus, the verification must contain the following. Number one, the allegations in the pleading are true and correct based on his or her personal knowledge or based on authentic documents. Yan, nasa current rules yan. Number two, ito wala. The pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And number three, the factual allegations therein have evidentiary support, or if specifically so identified, will likewise have evidentiary support after reasonable opportunity for discovery. Yaan, kailangan na yan kasama sa verification. Okay. What is the purpose ba of verification? It is to secure an assurance that the allegations in the pleading are true and correct and have been filed in good faith, according to the case of Salenga versus Court of Appeals. Now, paano kung defective yung verification? May nagkulang kayong paragraph. Yaan ba i-dismiss ng korte? Sabi sa kaso ng Torres versus Padilla 2012 case, a defective verification is merely a formal defect which does not affect the jurisdiction of the tribunal. Kaya anong gagawin nung plaintiff? Kunwari, plaintiff dapat nag-file ng verified complaint. Napansin ng defendant, kulang-kulang yung verification. Mag-file lang siya ng motion na ipa-verify niya yung complaint. At kung yung court mag-issue ng order na i-verify yung complaint, dapat sumunod ang plaintiff at magbigay siya at baguhin niya yung verification and let the verification comply, okay? Comply with the rules. Okay, now, Section 5, Certification Against Forum Shopping. Okay. Okay. Yung provisions currently, isang amendment na na-introduce dyan. Okay. And yung amendment na yon is the authorization of the affiant, okay, to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading. Okay. So anong ibig sabihin nun? Kung kunwari korporasyon, no? At magkakaroon ng certification on non-forum shopping, the authority of the person executing the certificate against forum shopping should now form part, okay, of that certification. Dapat naka-attach. Okay. Please take note of the general rule on the rules on certificate of non-forum shopping. What is the general rule? According to the case of Loquias versus Ombudsman, it is the plaintiff or the principal party who shall certify under oath that he has not commenced any action involving the same issues in any court. Okay? The attestation contained in the certification requires personal knowledge by the party who executed the same. So the rule is hindi pwede abogado, dapat parties. At lahat ng petitioners or plaintiffs dapat mag-execute sila. Yan ang general rule according to the case of Loquias versus Ombudsman. Ngayon, ano yung exception sa general rule? Isa dyan yung kaso na nabanggit ni Docena versus Lepasura. Okay. When the plaintiffs, okay, the interests of the plaintiffs are closely intertwined because in the case of Docena versus Lepasura, mag-asawa yan eh, husband and wife. Ang subject ng kaso, conjugal property nila. Ngayon, ang nagpirma lang ng certificate of non-forum shopping is just what? Is the husband, hindi sinama yung wife. Defective ba yun? Dapat ba i-dismiss yan? The answer is no. There is no justifiable reason, according to the Supreme Court, why he may not lawfully undertake together with his wife to inform the court of any similar action or proceeding which he may be filed. If anybody may repudiate that certification or undertaking for having been incorrectly made, it is the wife who may conceivably do so. Okay. The husband may reasonably be presumed to have personal knowledge of the filing or non-filing of his wife of any action because precisely their interests are directly intertwined. Okay, now. So, okay, in fact, in the case of heirs of Gallardo versus Soliman, okay, the signature of one of the petitioners in the certification against forum shopping substantially complied with the rules because all the petitioners share a common interest and invoke a common cause of action or defense. Pero kung hindi sila common cause of action, hindi common defense, for example, okay, common cause of action rather, okay, or common interest, dapat lahat ng plaintiffs, lahat ng petitioners mag-execute ng certificate of non-forum shopping. Now, sa isang kaso, Chua versus Torres, okay, may magkapatid sila, brother, sister. The brother issued a check, okay, and now the check was dishonored. Now, a civil case was filed against the brother. A criminal case was filed against the brother. Kaya lang nung sinerve yung warrant of arrest, ang naaresto yung sister. Nurse pa naman yung sister sa nursing school. Siya yung naaresto, so siya yung nakulong. Eh wala naman siyang alam dun sa kaso. So what the sister did was to file a civil case against the plaintiff, the complainant, and now defendant. No? So dinimanda niya, pero ang nangyari, it is sister and brother versus the defendant. Okay. Sabi ngayon ng defendant, okay, dapat i-dismiss because ang pumirma lang ng certificate of non-forum shopping was the sister. The brother was not included. Now, anong sabi ng Supreme Court? Actually, based on the allegations of the complaint, the brother is a misjoined party. Wala naman siya sa kwento. Kanino ba yung cause of action? The cause of action belongs to the sister, hindi naman doon sa brother. Sino bang inaresto na walang basihan? It was the sister, hindi yung brother. Pero, so sabi, kaya, ang sabi ng Supreme Court, since the misjoined party plaintiffs receives no recognition from the court as either an indispensable or necessary party plaintiff, then it follows that whatever action or inaction the misjoined party may take on the verification or certification against forum shopping is inconsequential. So anong ibig sabihin nun? Na ang dapat mag-execute ng certification, okay, eh yung either yung necessary or indispensable party. Pero kung misjoined party ka, okay, at hindi ka naka-execute ng certification on non-forum shopping, okay lang kasi sa totoong buhay, hindi ka naman dapat talaga kasali. Okay. Now, there is a rule when it comes to juridical entities. Okay. The following officials, and this is the general rule as held in the case of Cagayan Valley versus Commissioner of Internal Revenue. Okay. The following officials or employees of the company can sign the verification and certification without need of a board resolution. Okay? And these are the following corporate officers who can sign the certification on non-forum shopping, okay, without need of a board resolution. Number 1, the president of a corporation. Number 2, the general manager or acting general manager. Number 3, the personal officer. And number 4, an employment specialist in a labor case. Yan, pwede yan mag-execute, okay, hindi na kinakailangan, okay, hindi na kinakailangan ng certificate ng board rests, okay? Okay, there's one question, and allow me lang to read the question because it came in from friend, okay? What is the effect of the failure to file a reply to an answer whose defense is founded on an actionable document? Okay, you are correct when you said that if you fail to file, okay, a reply to an answer that is based on an actionable document, then the due execution and authenticity, okay, then the due execution and authenticity of the actionable document are deemed admitted. But all other allegations pursuant to Section 10 of Rule 6 are deemed controverted. Okay, is that clear? Okay, now. So, let's now go to contents. Okay, and again, this is one of the heavily amended one. Let me just read the provision, please. Okay. Every pleading stating a party's claim or defenses shall, in addition to those mentioned or mandated by Section 2, Rule 17, okay, Rule 7, I'm sorry, state the following. Okay. Names of witnesses who will be presented to prove a party's claim or defense. Again, I will repeat that. Every pleading stating a party's claim or defenses, so every complaint or answer, okay, shall, in addition to those mandated under Section 2, Rule 7. Ano ba yung Section 2, Rule 7? Okay? Yung Section 2, Rule 7, okay, just give me a minute, please. Okay? Section 2, Rule 7, okay, ito yung, okay, ito yung paragraphs, yung the body, okay, yung nilalaman. In addition to that, ano pa dapat ang nakalagay sa complaint or answer? Number 1, the names of witnesses who will be presented to prove a party's claim or defense. Number 2, summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part hereof. Number 3, only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witnesses or affidavits shall be heard or submitted by the court. Letter C, documentary and object evidence in support of the allegations mentioned in the pleading. Okay. Let me just focus on Section 6 because, as I said, that's a new provision. Okay. And kumbaga yung foundation ng pagkaalam natin ng paano maggawa ng pleading, iba na. Okay. Because of Section 6. Okay. Now, Section 1, Rule 8. Okay, let me just refer you first to Section 1, Rule 8. Requires that every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his or her claim or defense. Including the evidence. Okay. So, consistent with Rule 8, Section 1, sabi ngayon ng Section 6, Rule 7, kailangan mo nang ilagay sa complaint mo at sa answer mo yung pangalan ng mga witnesses, okay, who you intend to present to prove your claim or defense, the summaries of their intended testimonies, and in fact, you are required to even attach, okay, even attach the judicial affidavits of your witnesses. At pag hindi mo na-attach, no other witnesses or affidavits shall be heard or admitted by the court. But I will clarify that when we hit Rule 18, no? And the documentary and object evidence in support thereof. Okay. First, what is the difference between ultimate facts and evidentiary facts? Okay. In the case of Far East Marble versus CA, ultimate facts are the essential and substantial facts which either form the basis of the primary right and duty or which directly make up the wrongful acts or omissions of the defendant. The term ultimate facts means the essential facts constituting the plaintiff's cause of action, which means if a fact cannot be stricken off, okay, without leaving a fact is essential or ultimate if it cannot be stricken off without leaving the statement of the cause of action insufficient. So kailangan na handun yung fact na yun kasi kung wala yun, wala kang cause of action. Let's differentiate it therefore with the word evidentiary facts. Kung ang ultimate facts is yung fact na dapat i-allege, at kasi kung hindi mo i-allege yan, wala kang cause of action, okay. Evidentiary facts are those which tend to prove or establish said ultimate facts, still as stated in the case of Far East Marble versus CA. Or they are the facts which furnish evidence of existence of some other fact. So ang complaint ngayon, ang defense ngayon, lalo na ang complaint, based on ultimate facts and evidentiary facts. Kaya kinakailangan lahat ng ebidensya na available na sa iyo, okay, bago mo pa i-file yung kaso, na handun na sa complaint. Okay. Anong ibig sabihin yan, okay, sa atin? Number one, because the JA is now required, okay, to be attached to the complaint or even to the answer. It impliedly amended, not modified, but amended, okay, the provisions on the JA rule. Bakit ko na sinabing it impliedly amended the provisions on the judicial affidavit rule? Kasi di ba sa JA, we are required to submit our judicial affidavits at least 5 days before the scheduled pre-trial conference. Under the rules now, particularly as stated in Section 6, okay, of Rule 7, yung JA kailangan naka-attach na yan. Okay. Anong implications niyan? Doon sa mga abogado hong nakikinig, okay, pag nag-file na ho tayo ng kaso, kunwari complaint, naku, talagang mahirap. Dahil hindi naman mahirap, dapat naman talaga alam natin kung ano yung ebidensya. Kaya lang mahaba na yung proseso only because pag file mo, dapat lahat nakaayos na yung ebidensya, which is only but right. No? Ang effect naman ngayon, paano yung defendant? Of course, the plaintiff has, as a long period of time, basta ba nasa prescriptive period pa yan, no? In the period, it can take sweet time, okay? Pwede siya ma-prepare yung complaint of JA ng more than 2 months. How about the defendant? Technically, the defendant under the new rules now is given a longer period of time within which to file an answer, okay, to the complaint. Hindi katulad noon 15, ngayon 30 calendar days. Okay? And in fact, it is only the general rule is you're no longer allowed to file a motion for extension of time to file a pleading, except in an answer. Okay? Except when you want to ask for additional period of time to file an answer, you can be given an additional period of 30 days. So theoretically, you may have 60 days within which to file your answer and your judicial affidavits. Okay? Hanggang dun ang pinaka-max mo. Okay, now. Okay, so we're done with Rule 7. Okay, go to Rule 8. Okay? Okay. Yung answer sa JA, kailangan na rin i-attach. I'm sorry, I saw a comment here. Yes, the answer of the defendant in the answer, the JA or the JA of the defendant's witnesses should likewise be attached to the answer. Okay. Section 1, Rule 8. Every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party relies for his or her claim or defense as the case may be. Okay. The second paragraph was amended. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her shall be clearly and concisely stated. Okay. You know, under Section 1 of Rule 8 of the 1997 rules, it is only when the defense is based on law that you are required to quote the pertinent provision of law. Now, the Section 1, Paragraph 2 was amended to the effect to include now that if your complaint or cause of action rather is based on law, you cite the pertinent provision of law, which I think is also correct. No? Okay. Section 2, no changes, and that's your alternative causes of action. Your conditions precedent, no changes. Section 4, on capacity, no changes. Same with Section 5. Okay. Now, let me now go to judgment, Section 6. Okay. In pleading, a judgment or decision of a domestic or foreign court, judicial or quasi-judicial, okay, of tribunal or a board of officer, it is sufficient to aver the judgment or decision without setting forth showing jurisdiction to render it. Okay. Why? Because precisely jurisdiction is presumed, no? An authenticated copy of the judgment or decision shall be attached to the pleading. Now, I draw your attention to Section 6, Rule 8, which now, Section 6, Rule 8, which now requires that an authenticated copy of the judgment or decision shall be attached to the pleading. I might as well bring to the attention of the listeners that it need not be consularized anymore. Okay? Kasi the Philippines being a member of the Hague Convention abolishing the requirement of legalization for foreign public documents, pwede na lang i-apostilize. Hindi na tayo pupunta sa consular office at para kumuha ba ng red ribbon. Okay? Pwede ka na lang magpa-apostilize. Okay. Now, Section 7, actually this one is action or defense based on an actionable document. Hindi yan nagbago. Okay? It should be attached. And how to contest such documents, hindi rin nagbago. But the way you contest an actionable document, of course, is you have to deny under oath the due execution and authenticity of the said document. You don't deny under oath, then it will give rise to a technical admission. Okay. Section 9, no change. Section 10, specific denial. Okay, except gender inclusiveness provisions, no change. Now, allegations not specifically denied, deemed admitted. If you read, and this is very short lang naman, may I ask you to just read Section 11. In Section 11 of Rule 8 of the 1997 rules, the material averments that are deemed admitted are those stated in the complaint. Okay. The amendment, okay, in Section 11 appears to be more inclusive and appropriate as it may now include material averments in a third-party complaint or even in an answer where a permissive counterclaim is being asserted. Okay. Okay. So let's start with Section 12. Affirmative defenses. A defendant shall raise his or her affirmative defenses in his or her answer, which shall be limited to the reasons set forth under Section 5B, Rule 6, and the following grounds. Okay. First ground, that the court has no jurisdiction over the person of the defending party. The venue is improperly laid. 3, the plaintiff has no legal capacity to sue. 4, that the pleading asserting the claim states no cause of action, and that a condition precedent for the filing of the claim has not been complied with. Now, so from actually yung 5B, Rule 6, at saka itong mga in-enumerate, yan daw pwede yung erase by way of affirmative defenses. Okay. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. The court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. As to the other affirmative defenses under the first paragraph of Section 5B, okay, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. Okay. Affirmative defenses, if denied, shall not be subject of a motion for recon or petition for certiorari, prohibition, or mandamus, okay, but may be, among others, to be raised on appeal after judgment on the merits. This is a new provision, okay, and let me discuss my understanding of it to you. Okay, now. Okay. The defendant must file an answer and raise all the grounds mentioned in Section 5C, Rule 6, okay, and those enumerated under Section 12 by way of affirmative defenses. Ano ba yung grounds under 5.6 Rule 6 of the 2019 rules? Number 1, fraud, statute of limitations, release, payment illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Pag yan daw ang in-erase nyo, hindi nyo yan marerase sa motion to dismiss. Unang-una, wala na yung Rule 16. Okay? Hindi daw, marerase lamang nyo yan sa inyong answer by way of affirmative defense. You may also in the answer include the following affirmative defenses. Okay? Court has no jurisdiction over the subject matter, litis pendentia, res judicata, and prescription of action. Okay? And of course, your grounds mentioned under Section 12, Rule 8, yung no jurisdiction over the person of the defending party, venue improperly laid, plaintiff has no legal capacity to sue, pleading asserting the claim states no cause of action, and that the condition precedent for filing the claim has not been complied with. In my mind, there are therefore 3 groups which you can raise by way of affirmative defense. The first group is composed of the grounds mentioned under 5C, Rule 6. Okay, that's the first ground. The second ground actually are the grounds, okay, yung tinatawag kong 4 na sikat, Section 1, Rule 9. Lack of jurisdiction over the subject matter, litis pendentia, res judicata, prescription. Okay. At saka yung third group will be your Section 12, Rule 8, yung lack of jurisdiction over the person of the defending party, venue improperly laid, etc. Okay. Please take note, okay, that under Rule 9, okay, Rule 15, Section 12 of the 2019 rules, okay, yun sa mga sinabi kong affirmative defenses, there are 4 affirmative defenses which you can raise, okay, in a motion to dismiss, pursuant to Rule 15, Section 12. At ano-ano yun? Court has no jurisdiction over the subject matter, litis pendentia, res judicata, and prescription of by statute of limitations. Okay, now, when we discuss Rule 15, okay, notice, okay, sa Rule 15, sa Rule 16, tinanggal na yan, yung mga grounds yan, i-erase mo by way of affirmative defense. Okay. What will be the action of the court? Kailangan mo pa ba mag-file ng motion to hear, motion for preliminary hearing to hear the affirmative defenses? The answer is no. Okay, that actually is in your Rule 16, but that was taken out. Okay, and number 2, under Rule 15 of the 2019 rules, that is a prohibited pleading. So, paano magiging action ngayon ng korte? Okay, the action of the court will depend on what affirmative defense you raise. Okay, if the affirmative defense is any of the grounds mentioned in Section 12, Rule 8, okay, And what are the grounds mentioned under Section 12, Rule 8? Okay. Again, when the court has no jurisdiction over the person of the defending party, venue improperly late, plaintiff has no legal capacity to sue, pleading asserting the claim states no cause of action, that the condition precedent for filing the claim has not been complied with. Anong magiging action ng court doon? Then the court shall on its own resolve the affirmative defense within 30 calendar days from the filing of the answer. Okay. Hindi na kailangan magkaroon pa ng hearing dyan. The court on its own can file, okay? Can decide on its own. And in fact, it is required to decide it within 30 calendar days from the filing of the answer. Now, if the affirmative defense is any one of the grounds mentioned under the first paragraph of Section B, 5B, Rule 6, okay? At again, ano yung mga grounds na yun? Fraud, statute of limitations, release, payment, illegality, statute of estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Ano ang maggagawin ng korte? The court on its own discretion, okay, may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses will be resolved by the court within 30 calendar days from the termination of the summary hearing. In other words, depende sa ni-raise mong affirmative defenses, yung magiging basihan ng action ng court. Okay. If the affirmative defenses you raise, okay, are those mentioned under Section 12, Rule 8, hindi na kailangang magkaroon ng preliminary hearing on the affirmative defense because the court on its own can resolve the matter. But if your ground is one of those mentioned under Section 6, okay, court, okay, then the court may conduct a preliminary hearing on it, okay? And then the court will decide whether the affirmative defense should be granted or not, okay, within a period of 30 days from the termination of that summary hearing. Okay. Now, bakit ganun ang treatment? How come dun sa isang group, yung court on its own, without a need for a summary hearing can resolve, but on the other group, okay, the court may conduct a summary hearing. The difference in treatment lies on the fact that the affirmative defenses mentioned in Section 5B, Rule 6, may require presentation of evidence, aliunde in support thereof. Of course, except of lack of jurisdiction over the subject matter. Okay, now, okay. Now what happens, for example, if the affirmative, okay, kung yung affirmative defense denied, okay, notice, you cannot file a motion for recon on the said denial of your affirmative defenses. And you are barred from even elevating the order, okay, denying your motion for recon via certiorari, prohibition, or mandamus. You are likewise barred, okay, from filing or elevating the denial of the or the order denying your affirmative defenses to what? To the CA via appeal, for example. Why? Because that's an interlocutory order. Okay. So what is your remedy kung yung affirmative defense mo ay dininay? Okay. Then you go to trial. And in the event of an adverse judgment, okay, you now appeal the said judgment and assign as one of the errors in the appeal the order of the denial of your affirmative defense. Okay. Now, may nagtanong sa akin noon, okay, paano kung yung affirmative defense, okay, ay ground na lack of jurisdiction over the person of the defendant. In other words, improper service of summons. Okay? Tapos dininay. Eh di sabi, di ba, hindi mo siya pwede i-appeal. Hindi ka pwede mag-MR dun sa order denying that affirmative offense. Defense, hindi ka rin pwedeng tumakyat via certiorari. Sabi, kung diretso ka daw ng trial, tapos mag-appeal ka na lang. would that not tantamount to voluntary submission? I think in that case, you should be very consistent when you participate in the court proceedings, that this is without prejudice to your right to question it, so that you will not be considered as having been stopped, okay, from raising that defense. Kasi the rule is very clear. You really cannot file a motion for reconsideration against the order denying your affirmative defense. Okay. Of course, if the court grants the affirmative defense, the order is no longer interlocutory. That's a final order, as it is. There's nothing else left to be resolved thereafter. So proceeding from that premise that it is a final order, then the plaintiff's remedy is to appeal the court's order granting the affirmative defense. Okay? Clear. And that's a case of Nuque versus Aquino. It's a 2015 case. Okay. Now. Okay. Now let's go to Section 13. Wala namang pagbabago dyan. Okay. Rule 9. Rule 9, effect of failure to plead. Okay? Okay. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, okay, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. Okay, let me just focus on this section 1. Okay. As a rule, pursuant to section 12A of Rule 15 of the 2019 Rules on Civil Procedure, a motion to dismiss is a prohibited pleading. Okay? It is a prohibited pleading. That's the general rule. Wala nang motion to dismiss. Except when the motion to dismiss, pursuant to the same rule, is grounded on the following: that the court has no jurisdiction over the subject matter of the claim, litis prudentia, res judicata, and prescription of action. Okay. Okay. And statute of limitations. Okay. Now, with the deletion of Section 1, Rule 6, tanggal na yung Rule 16, di ba? Sinabi ko kanina, tanggal na siya. Okay. The question is, what is the period of time within which to file a motion to dismiss? Kung natatandaan natin yung Rule 16, as it's currently worded now, you file a motion to dismiss within the period for you to file a responsive pleading. Remember, the entire Rule 16 was now taken out. So ang tanong natin, kailan tayo pwede mag-file ng motion to dismiss? I think even if, okay, that was already taken out, you should file your motion to dismiss, okay, as a general rule, within the period to file an answer, which means within 30 days. Okay. Bakit? Kasi kung hindi ka mag-file ng motion to dismiss, di ka nag-file ng answer, madedeclare ka naman in default. Okay. Now, but there is a case, okay, and this is the case of Panganiban versus Philippine Shell. It's a 2003 case. The requirement that the motion to dismiss should be filed within the time for filing the answer is not absolute, okay? Even after an answer has been filed, a defendant can still file a motion to dismiss on the following grounds: lack of jurisdiction, litis pendentia, lack of cause of action, and discovery during trial of evidence that would constitute a ground of dismissal. Okay, now. Okay. So as I said, the general rule, even if you can file a motion to dismiss based on those 4 grounds, you can only do that, okay, within the period to file a responsive pleading, or again, based on the jurisprudence, Panganiban versus Philippine Shell, you can do that even after the filing of the complaint. Okay. Okay. Section 2, compulsory counterclaim or cross-claim not set up, barred, no changes. Okay. And then default. Okay. Let me just discuss sections 3. Okay. Section 3. Okay. Yung default na yan. Okay. Even if walang pagbabago. But let me just discuss it. Okay. When you fail to file, okay, when you fail to file your answer against a complaint within the period, the plaintiff rather, may file a motion to declare you in default. Okay. And if you file a motion to declare defendant in default, ang titiglan lang naman dyan, kailan sinerve yung summons, kailan natanggap. No? Pangalawa, okay, nakapag-file ng answer. If you received if you were properly served summons and you failed to file an answer, okay, what is the next move of the plaintiff is to file a motion to declare you in default. So if you were properly declared in default, what will be your remedies? Okay. Within the period, okay, basta before judgment by default, you can file a motion to set aside order of default, which is supposed to be verified, based on fraud, accident, mistake, or excusable negligence. And of course, you have to attach your affidavit of merit. Okay. Pag nakuha mo na yung judgment by default, ano naman ano ang iyong remedies? Okay, within the period to file an appeal, you can file a motion for recon, you can file a motion for new trial, you can even file an appeal. Natapos, hindi mo pa rin nagawa. Okay. For reasons not attributable to you, I have to stress that. Okay. Now, ano ang remedy mo? You can file a Rule 38 petition for relief from judgment. That's again based on fame and affidavit of merit. Okay. Pero please file a petition for relief from judgment. Okay. You better make sure that you will be able to explain to the court why you're not able to avail of a motion to set aside order of default, because this is already a remedy in equity. Okay. So those are the remedies. Can you consider Rule 47 a remedy? My submission is yes, which is a petition for annulment of judgment. But notice that the petition for annulment of judgment under Rule 47 is very specific as to the ground. Hindi fame, it's just fraud, extrinsic fraud. Tulad din ng extrinsic na fraud sa petition for relief of judgment and motion to set aside order of default. Okay. Those will be your remedies if you were properly declared in default. But what if you were improperly declared in default? Well, the case of Indiana Aerospace says, okay, teaches us that the remedies, you file a motion for reconsideration, and if it's denied, then you go up on certiorari, okay, according to the case of Indiana Aerospace. Okay. Pag na-declare ka bang in default, okay, pag na-declare ka bang in default, pwede ba kung magkano na lang ang bigay sa iyo ng korte? Okay, the answer is no. Why? Because according to the rules, okay, a party declared in default, okay, yes, you're not entitled to participate anymore, but you are entitled to notices, okay? And what can be the extent of relief to be awarded? It can be a judgment rendered against a party in default shall neither exceed the amount or be different in kind from that prayed for. Ang prayer mo, specific performance, tapos ang binigla namang ginawa ng court, inanal yung agreement. Okay? A specific performance yung agreement ang gusto mong relief. At hindi pwedeng magbigay or award unliquidated damages. So hindi pwedeng mag-award ng moral damages, exemplary damages, because that is what is under the law. Okay. Now, there can be no default. Okay, what happens, for example, if a plaintiff sues 3 defendants based on the same cause of action? Defendant A filed an answer, B and C did not. Can B and C be declared in default? The answer is no. Because they are sued on the same cause of action, the answering defendant's answer will inure to the benefit of the non-answering defendant. They will not, that these two did not answer, will not be declared in default. There can also be no declaration on default, okay, in actions for petition for annulment of marriage, petition for declaration of nullity of marriage, and of course, for petitions for legal separation. Okay. Now let's go to Rule 10, amended and supplemental pleadings. Okay. Okay. Okay, Rule 10. Amendments in general. Pleadings may be amended by adding or striking out the name of any party, or by correcting a mistake in the name of a party, or a mistaken or inadequate allegation or description in any other respect, so that actual merits of the controversy may be speedily be determined without regard to technicalities in the most expeditious and inexpensive manner. No change as far as Section 1 is concerned. Section 2, amendments as a matter of right. A party may amend this pleading once as a matter of right at any time before a responsive pleading is served, or in the case of a reply, at any time within 10 calendar days after it's served. As I said, ito yung isang example ng ang amendment lamang ay instead na 10 days, 10 calendar days. Okay. Now let's go to Section 3. Diyan merong amendment. Okay. Except as provided in the next preceding section, which is, okay, substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Okay. Orders of the court upon matters provided in the section shall be made upon motion filed in court and after notice to the adverse party and an opportunity to be heard. Okay, now, my comment only. Okay. A party may amend his pleading once as a matter of right. Okay, once. As a matter of right at any time before a responsive pleading is served. But the court may, upon motion at any stage of the action and upon such terms as may be just, order to give leave to a party to amend his pleading to the end that the real matter in dispute and all matters in the action in dispute between the parties may be completely determined in a single proceeding. Even after an order dismissing his complaint is issued, an amendment may still be allowed. The motion to amend should be filed before the order of dismissal becomes final and unappealable, because thereafter there would be nothing more to amend. That is Constantino versus Reyes. Okay. Now, but I have lang a question, no? Kasi nakalagay sa Section 3, except as provided in the next preceding section, which means amendments, okay, as a matter of right, except that, okay? Substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was meant with intent to delay or confer on the court jurisdiction, or the pleading stated no cause of action. So I filed, okay? I filed, let's say, a complaint. Yung complaint, ang nakalagay, collection suit. Ang complaint, ang nakalagay, ito yung final ko sa RTC. Ang amount ng complaint, let's say, is 300,000 pesos o 250,000 pesos. Final ko sa RTC, di ba sobrang mali yun? Kasi walang jurisdiction naman ng RTC to hear and decide complaints involving a collection suit of 250. And then I realized nagkamali ako. Okay. Sabi, ito ha, I'm just reading Section 3. Except as provided in the next preceding section, which is what? Amendments as a matter of right. It would appear I can amend. Diba? I can amend to the end that I will now amend to confer jurisdiction to the court. But if I filed an answer and there is now, if I filed a complaint and now there is now an answer, and the answer raises, okay, an affirmative defense that is that the court has no jurisdiction over the subject matter. Kahit na walang affirmative defense. Why? Because a court on its own can dismiss the complaint. Look at this part of Section 3, okay? But such leave shall be refused, if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. So my question actually in my mind is this. If I filed a complaint and the complaint does not state a cause of action, okay, or stated no cause of action, or that the court has no jurisdiction to entertain my complaint, if I'm going to file or amend my complaint as a matter of right, based if you read Section 2 and 3, mukhang pwede. But if you are going to amend your complaint no longer as a matter of right, but by leave of court, hindi ako po pwede because it's very clear here that the leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Okay. Okay, section 4, nothing new. Okay, nothing new. Okay. Section 5. Okay. Section 5. No amendment necessary to conform to authorized presentation of evidence. When issues not raised in the pleadings are tried with the express or implied consent of the parties, okay, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. Actually, that is based on jurisprudence. Anong ibig sabihin nun? Kunwari sa complaint ko, I did not raise the issue of moral damages. Okay. Di syempre sa answer, wala rin na moral damages. Nag-pre-trial ngayon kami. Wala rin dun sa pre-trial order yung issue ng sino ba damages. But nung nag-present na ako ng ebidensya, I presented a witness for the purpose of proving moral damages. Walang objection yung kabila. Ganun din naman yung kabila. Okay? Now, because it was an issue that was not generated by the pleadings, nor was it an issue that was stated in the pre-trial order, but was expressly tried on by the parties. Okay? Pumasok na yung ebidensya. Do I have to file a motion, okay, to amend my complaint, okay, in order to conform with the evidence presented? The answer is no. It is not fatal, in other words, if you don't move to have your pleadings amended to conform with the evidence presented. Okay. Supplemental pleadings, okay, wala naman din masyadong pagbabago, paglilinaw lang, gender inclusiveness, and 10 calendar days, okay? Okay. In other words, the adverse party may plead thereto within 10 calendar days from notice of the order admitting the supplemental pleading. Filing of amended pleading, okay, no change. Effect of amended pleading, okay. And the amendment here really conforms to evidence. Okay, let me just read first section 8 to you. An amended pleading supersedes, okay, the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader in claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. Okay. As I said earlier, this amendment actually incorporates only the teaching by the Supreme Court. In the case of Ching versus CA, okay, under the rules, pleadings superseded or amended disappear technically from the records. And what do I mean by disappear? They lose their status as pleadings and they cease to be judicial admissions. They no longer form part of the records of the case. Why? Because when you amend a pleading, that original pleading is deemed vacated. While they may nonetheless be utilized against the pleader as extrajudicial admissions, they must, in order to have said effect, be formally offered in evidence. Pwede yung gamitin as ebidensya, pero kailangan mo yun i-offer in evidence. In other words, kailangan mong ibalik sa records through a formal offer of evidence. Okay? Which means I have to call a witness to identify that document, okay? And offer it sa formal offer of evidence at sabihin ng korte, okay, admitted. Consequently, if there is now an admission, the original complaint, having been amended, lost its character as a judicial admission, which would have required no proof and became merely an extrajudicial admission, the admissibility of which as evidence required its formal proof. Okay, clear. Okay, when to file pleadings. Okay, this is what I'll do. I will just summarize. Okay, summarize lang natin yung section 11. Okay, if the answer to be filed is if if the pleading to be filed is an answer, okay, you have a period of 30 calendar days from personal service or substituted service of summons, okay, within which to file your answer unless a different time is fixed by the court. That is on the basis of, that's the same period for answers to third-party complaints. Okay. Okay, may question lang, sorry ha, may napansin lang ako. May motion to dismiss. Yung may nagtanong, yung remaining period, these 5 periods, I will discuss that when we hit motion to dismiss. Ha? So not muna. But I will answer that question. Okay. Now, how many days are you supposed to file an answer if the defendant is a foreign juridical entity? Now, if summons was served, let's say, on a resident agent of that foreign juridical entity, it's 30 days. But if the summons to that foreign juridical entity, okay, was served, okay, was given, let's say, on a government official designated to the said defendant, then the answer should be filed within 6 days, calendar days, from receipt thereof. Okay. How about an answer to an amended complaint? Okay, when an amended complaint was filed as a matter of right, then the answer to the amended complaint that was filed as a matter of right should be 30 calendar days from service of summons. However, when the amended complaint was not filed as a matter of right, which means an answer had already been filed, okay, you want to file an amended answer to the amended complaint, you are given a period of 15 calendar days from notice of the order admitting the same. Please take note that when an answer had already been filed to the complaint and the complaint was no longer as a matter, okay, even if you did not file an answer to the said amended complaint, you will not be declared in default. The answer to the original complaint you filed will stand as your answer to the amended complaint. However, all the matters that you did not address in the amended complaint will be deemed admitted. Okay. Now, what is the period to file an answer to a supplemental complaint? Okay. The period is within 20 calendar days from notice of the order admitting the same, unless a different period was fixed by the court. Okay. Now, again, the answer to the complaint shall be served as the answer to your supplemental complaint if no new supplemental answer was filed. Okay. Now, how about, okay, answer to a compulsory or permissive counterclaim or cross-claim. You have a period of 20 calendar days, okay, within which to file your answer to either a compulsory or a permissive counterclaim. Remember, you don't file an answer to a compulsory counterclaim, okay lang yan. You don't file an answer to a permissive counterclaim, you're dead. Why? Because you can be declared in default. Okay. Reply. Okay. If reply is allowed under Section 10, Rule 6, and when will reply be allowed? If the answer is founded on an actionable document. Okay. You have a period of 15 calendar days from service of the pleading responded to file the reply. Okay. Answer to bill of particulars. Okay. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars. If pleading is a reply, the motion must be filed within calendar days. Then if it's granted, your period to file an answer will be 10 days. Okay, now, how about if the summons was served by publication pursuant to sections 15, 16, 17, 18 of Rule 14? Okay? Ang summons pinublish, ilang araw ang pwede? Okay, mag-file. Okay, it should be 60 days after notice. Okay. Bakit hindi ko sinama yung section 14? Kasi sa section 14, walang nakalagay na period. Pero yung Section 15, 16, 17, 18 ng Rule 14, malinaw na may period. Okay, now, answer in intervention, okay? You file your answer in intervention to the complaint in intervention within 15 calendar days from notice of the order admitting the same, unless a different period was filed. Okay, was stated by the court. Okay. Of course, the period to file an answer to, let's say, a complaint filed under the rules on summary procedure is 10, and the response to small claims will also be 10. Okay, may ilang nagtatanong, okay? Sabi ganito daw. Okay. Okay. Remember that a motion to dismiss, the only way you can file a motion to dismiss under the 2019 rules, kung ang motion to dismiss mo is predicated on the four grounds. Lack of jurisdiction over the subject matter, jurisprudensya, res judicata, and prescription. Let's assume deny. Okay. Ilan daw yung period to file an answer? Okay. Remember that the entire of Rule 16 was deleted. Wala na siya talaga. Wala na. Okay. Doon sa Rule 16, doon nakalagay, yung Rule 16 na natanggal na, no? Nakalagay doon, you have the remaining period of time, but not less than 5 days within which to file an answer should your motion to dismiss be denied. Okay? Or is denied. Inatanggal na nga yung provision na yun. So ano na yung period mo within which to file an answer? This is my personal take on it. You only have the remaining period within which to file an answer. Wala na yung in no case, in no instance will be not less than 5 days. Wala na yun. You only have the remaining period. Therefore, if you filed your motion to dismiss on the 30th day, okay, deny, technically you have only 1 day to file an answer. But remember, under the rules, you can file a motion for an extension of time once, okay? If you're going to ask for an extension of time to file an answer. So, anong remedy dapat dyan? Dapat siguro in practice. Huwag nating hintayin naman ang 30 days nung ka mag-file ng motion to dismiss mo. Pwede mong i-file. Ano ba naman yung 15 days? Di mag-file ka ng motion to dismiss ng 15 days, okay? Para pag dininay, you have the remaining period of 15 days. Plus, kung hindi pa sufficient ka to file an answer, as I said, the rules will allow you to file a motion for extension of time to file an answer within a period of 30 days. So technically, you have 45 days, okay, within which to file an answer. Kaya siguro tininggal yung provision na yun. Kasi, i-file mo lang yung motion to dismiss mo, ang haba ng period eh. Kung ipa-file mo early, now you will suffer the consequences if you file it on the last day. Dahil ang ginagawa mo dyan, yung motion to dismiss mo, imagine huwag mong sagalin yung 30 days para may sufficient period of time pa. Okay. Now, Section 2, okay, as I've said, no, I discussed the period of time I summarized the period of time, so I will now move on to Rule 12. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter which is not averred, with sufficient definiteness or particularity to enable him or her properly to prepare his or her responsive pleading. If the pleading is a reply, the motion must be filed within 10 calendar days from service thereof. Such motion should point out the defects complained of, the paragraphs wherein they are contained, and the details desired. The only change there is you refer to gender inclusiveness. Okay. Now, action by the court, no change. So Section 2 on Bill of Particulars, still the same. Same with Section 3. Okay. And also with Section 4. Actually, sa Bill of Particulars, talagang walang pagbabago. As is. Okay. Now, let us now go to filing and service of pleadings. Okay. Tandaan natin, pag sinabi yung word na okay, yung verb na file in court. Okay. Serve, yung verb na yan, you associate it with the other party. So you serve first to the other party and then file in court the pleading. Okay. Now, Section 1, mas lumawak at mas naging mas malinaw because Section 1 provides This rule shall govern the filing of all pleadings. Now it includes motions and other court submissions, as well as their service, except those for which a different mode of service is prescribed. Okay, now, Section 2. Okay, and this is important. Okay. Filing is the act of submitting the pleading or other paper to the court. Service is the act of providing a party with a copy of the pleading or any other court submission. If a party has appeared by counsel, service upon such party shall be made upon his or her counsel, unless service upon the party and the party's counsel is ordered by the court. So general rule, you appear through counsel, everything will be reckoned from the receipt of the counsel. At dun sa counsel mo, dun ka magsaserve. Okay. Where one counsel appears for several parties, such counsel shall only be entitled to one copy of any paper served by the opposite side. Where several counsels appear for one party, such party shall be entitled to only one copy of any pleading or paper to be served upon the lead counsel if one is designated, or upon any one of them if there is no designation of a lead counsel. Maganda itong amendment na to, lalong-lalo na if you have a battery of lawyers. Tama lang naman na sabihin sa korte, sino dito sa mga abogado ng plaintiff ang lead counsel? Okay, bakit? Kasi pag na-designate na yung lead counsel, okay, isa lang yung bibigyan mo ng, he is the only one entitled to receive a copy of everything. Okay? Sa kanya din magsisimula yung bilangan. Kunwari, mag-file ng appeal. Sa kanya magbibilang kasi siya yung lead. Ang mahirap, marami kayong abogado, let's say for the defendant, walang na-designate na lead counsel, magtatawagan pa kayo, sino, natanggap mo na ba, natanggap mo na ba? Kasi ang rule na mangyari, kung sino una nakatanggap, dyan magsisimula yung bilang kung kailangan mo kunwari mag-appeal. So this one actually is a very good amendment because now it's very clear that for purposes of orderliness and case management, the lead counsel should be identified. Okay? So without a lead counsel being designated, as held in the case of Philippine Ports Authority versus Sargasso Construction, notice to any one of the several counsels on record is equivalent to notice to all, and such notice starts the time running for appeal, notwithstanding that the other counsel on record has not received a copy of the decision. Okay. Now, Section 3. Okay. The filing of pleadings and other court submissions, which will include your motions, shall be made A, submitting personally the original thereof, plainly is filing in court. How do you do that? Personally, sabi sa A. B, sending them by registered mail. That's the second. Third, sending them by accredited courier. You know, yung private courier, tulad ng LBC, kunwari. Kung accredited court, ha? Transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped. Okay. In the first case, the clerk of court shall endorse on the pleading the hour and the date and hour of filing. In the second and third cases, the date of motions, pleadings, and other court submissions, and payments or deposit as shown by the post office stamp on the envelope or the registry receipt should be considered as the date of their filing, payment, or deposit. The envelope should be attached to the record of the case. In the fourth case, the date of the electronic transmission should be considered as date of filing. Okay. So based on the amendment, what are the different modes of filing in court? Number 1, personal. Okay. Number 2, registered mail. Pwede private courier, but the private courier must be accredited by the court. Dapat siya, hihingi ka ng listahan sa korte, sino ba accredited private courier? Hindi porke malaki yung private courier at kilala, ayan, automatically dito natin ipadala. Tignan nyo muna kung siya ay accredited ng korte. At itong huli, with prior approval of the court, you can do your filing via electronic mail. Pero ang importante sa electronic mail ito, it has to be with prior approval of the court. And the court must be in a place where the court is electronically equipped. Okay? Dapat ang court electronically equipped tumanggap ng electronic filing. So ang tanong dyan, okay, pwede ko ba, okay, i-serve ko yung kopya dun sa kabila, let's say personal, eh hindi ako aabot sa korte. Pwede ko bang i-serve via Viber? I-serve via Facebook? Kasi electronic naman din yun, di ba? Pwede ba yun? Ito ang aking sariling opinion. Okay. Ang sinasabi, yung court electronically equipped. Hindi yung staff ng court na may Viber or na may Facebook, siya kung meron siya, ibig sabihin pwede ka na mag-file. Okay, no. It is the court that should be electronically equipped, but most important, you can only do electronic filing if you were able to obtain the prior approval of the court. Okay. Now, there's a question here. Who will accredit the couriers? I think it will be the Supreme Court. Para lahat pare-pareho, no? Okay, I think. Now, the second paragraph of Section 1, Rule 1329. Okay. May I refer you again to the second paragraph? Kasi may tanong din ako dito. I hope you don't understand. I hope you understand that sometimes I would like to voice also my questions. Because this is the first time, of course, that we're discussing the rules. And it's still, you know, we need guidance from the Supreme Court, and of course, it will take some time before siguro a case will be decided by the Supreme Court involving these provisions. Kaya lang kasi dito sa second paragraph of Rule 3, and I will repeat it, no? In the first case, the clerk of court shall endorse on the pleading the date and hour of the filing. Okay. Second and third cases, at ano ba yung second and third? Registered mail and sending them by accredited courier. Listen carefully. The date of the mailing of the motions, pleadings, and other court submissions and payments or deposits as shown by the post office stamped on the envelope or the registry receipt shall be considered as the date of their filing. Ang nag-i-issue lang, okay, ng post office stamp at ng registry receipt is if you filed it by registered mail. So if you read the second paragraph, the second sentence of the second paragraph, the date of filing, when is the pleading deemed filed if it was filed through private courier, okay? Hindi nakalagay dito sa second paragraph, okay, of the rule. Why? Because the second sentence, even if it says in the second and third cases, the following phrases, the remainder of the sentence would refer only to the second mode of filing, which is by registered mail. So in my mind, again, I ask the question, will the ruling in the case of heirs of Numeriano versus Miranda still apply? And what is the ruling? The date of delivery of pleadings to a private letter forwarding agency is not to be considered as the date of filing thereof in court. Instead, the date of actual receipt by the court, okay, is deemed the memo of filing of that pleading. Okay. Hindi katulad kasi nung, okay, we go back to the second. If I filed it by personal, kung kailan tinanggap ng clerk of court, yun ang date of filing. Pag sinend ko by registered mail, okay, ang date of filing ko is kung kailan natanggap, okay, nung post office, okay, as shown by the post office stamp on the envelope or registry. Pero pagdating sa private courier, ano ang araw na deemed filed ito? Hindi naman nailagay. Okay. Now, the last one is in the fourth case, the date of electronic transmission shall be the date considered as the date of filing. Ano ba yung date of transmission? Kung kailan mo pinundot yung send. Kaya very important, I think, in practice. Dapat wag natin buburahin yung bang sa send box. Okay, dapat ka kukunan ng picture yun para meron kang record kung kailan mo pinadala. Because that will be your proof of the date of filing. It's the date of electronic transmission. Okay? Okay, now, in Section 4, okay, My question dito, do we have a definition for electronically equipped based on the rules? There's no definition as to when can you consider a court electronically equipped. Okay. Section 4. Every judgment, resolution, complaint, retention, disappearance, demand, offer, judgment be filed upon the parties affected. Okay, no change in Section 4. Okay. Section 5. Modes of service. Okay. Pleadings, motions, notices, orders, judgments, and other court submissions shall be served personally or by registered mail, accredited courier, electronic mail, facsimile transmission, other electronic means as may be authorized by the court or as provided for international conventions to which the Philippines is a party. As I mentioned earlier, if we're talking about service to the adverse party. Okay. So what are the modes of serving a pleading, let's say, to the adverse party? You have personal service, you have registered mail, you have court-accredited private courier, then you have your facsimile transmission, other electronic means. Okay? But notice when you do facsimile transmission or electronic means or any electronic means, it has to be authorized by the court. Huh? And then, of course, as may be provided for international conventions to which the Philippines is a party. And I will also include as a mode of serving a pleading, Section 8, Rule 13 of the 2019 rules, substituted service of pleadings. Okay. Can I also include ordinary mail pursuant to Section 7, Rule 13? Yes, if there is no registry. Okay, if there is no registry, if it cannot be served through registered mail, that is allowed under Section 7, Rule 13. Okay, I will repeat again, for purposes of facsimile transmission or other electronic means, and you have to serve it to the other party, it has to be with prior court approval. Okay. And in fact, the parties must agree, as will be shown later. Okay. Now, okay. Okay, there I cannot help but look and see. I see. What is the procedure for seeking prior court approval from the court? You just have to file a motion in court, and the court may treat it as a non-litigious motion. Okay, and the court can make a ruling on it. Just file a motion. Okay, Section 6, personal service. Court submissions may be served by personal delivery of a copy to the party or to the party's counsel or to their authorized representative named in the appropriate pleading or motion, or by leaving it in his or her office with his or her clerk or with the person having charge thereof. Okay. If no person is found in his or her office, his or her office is not known, or he or she has no office, then by leaving the copy between the hours of 8 in the morning and 6 in the evening at the party's or counsel's residence. If known, with a person of sufficient age and discretion residing therein. So what are the modes of personal service? Personally delivering of a copy to the party or the party's counsel, or the authorized representative as mentioned in the pleading. Kung sa opisina ipapadala yung pleading, okay, dapat iwanan mo yan with a clerk or person in charge. Notice there is no time stated in the rules. But if there is no one is found in the office, or if the office is unknown, or he has no office at all, then you leave between the hours of 8 to 5, okay? 8 in the morning and until 5 in the afternoon, at the party or counsel's residence, if known, and you leave it with a person of sufficient age and discretion residing therein. Incidentally, okay, yung Rule 13, Section 613, yung priority in service, di ba ang nakalagay doon sa current rules, no? Section 13, Rule 13, ang priority ng service is always, and filing is always personal. And you have to have a written explanation why you were not able to file and serve it personally. Yung requirement na yan, Section 13, Rule 13, ay wala na. Okay? Under the 2019 rules, natanggal ho yung provision na yan. Okay. I do not know why. Maybe because if the court, if you can file, if you can file electronically and it was approved by the court and both parties agreed, kaya siguro hindi na kailangan. Okay. Now, Section 8, substituted service. Substituted service is different from substituted service of summons. Okay? Substituted service of pleadings. Requisites before substituted service can be resorted to. If you read Section 8, you can have substituted service if there's failure to personally serve the pleading and failure to serve by registered mail. Sineserve mo yung pleading sa kabila, walang tao doon, yung pala out, wala na. Okay? Hindi alam kung saan. Sinerve mo by registered mail, bumalik sa'yo yung registered mail. Then service may be made by delivering the copy to the clerk of court with proof, okay, of failure of both personal service and service by mail. The service is complete at the time of such delivery. What does that mean? Ang klaro sa Section 8, bago ka mag-substituted service of summons, ang kailangan lang, there's failure to serve it personally and by registered mail. Hindi mo kailangang pakita na even yung service by electronic, okay, failure. Hindi. Yung dalawa lang yun. Paid personal service and by registered mail. Pag napakita mo na yon at may proof ka, then you go to court, okay? And you now file it with the clerk of court with proof of failure of both personal service and service by mail. The service of that pleading is complete at the time of such delivery. Okay. Now, medyo sandali lang ha. I'm trying to catch my breath. Wait lang. Okay. Now, look at your Section 9. Okay. Service by electronic means and facsimile. Nakakita pa ng fax machine. Okay? Kasi magkaramihan ng opisina wala ng fax machine. Okay? Now, service by electronic means and facsimile. Service by electronic means and facsimile shall be made if the party concerned consents to such mode of service. So aside from it has to be approved by the court, the other party must give his or her consent. Service by electronic means shall be made by sending an email to the party or counsel's electronic mail address or through electronic means of transmission as the parties may agree on or upon discretion of the court. Service by facsimile shall be made by sending a facsimile copy to the parties or counsels given facsimile number. Okay. So the parties must agree, as I said, to have the pleading served either through facsimile or through electronic means. Okay. And please take note, it must likewise be authorized by the court pursuant to Section 5, Rule 13 of the 2019 rules. Okay. Service by electronic means shall be made by sending an email to the party or counsel's electronic email address. Okay, let me just discuss this thing. We have our own personal email addresses. Okay. Sometimes, some law offices would even assign you your office email address. Now, and this is for the law firms to consider. If, let's say, you have many associates and you gave your associates separate individual email addresses, and your associate now submits to the court the, let's say, the email address, kunwari, Pedro Santiago at the law office, for example, is cruzlaw.com. Pag yan ang ibinigay mo, pag binigyan ka ng kopya ng kabila, yan ang gagamiting email address. Right? Okay. Eh, paano kung nag-resign si associate? Tapos hindi naman alam ng court na nag-resign si associate. Tapos hindi nyo nasabi na dahil nag-resign na yan, doon pa rin doon pupunta. Okay? yung email na manggagaling dun sa kabila. So I think for proper or proper procedure, I think what you should give is the main, okay, email address of the law office, okay, which can be accessed by anybody. You can have one person designated as the email process, whatever person, who will be in charge of checking every day the emails and will be the one forwarding it to the different lawyers, instead of allowing the associate to use his or her email address. Okay? Baka magkagulo later on. Okay. Now, as I said, okay, question, based on paragraph 3, what if the parties agree? Okay, and then can the court direct the service of pleadings be done through Facebook or Viber? Okay, that's a question just being posted. Okay, presumptive service. Okay, what is the mode of obtaining consent? You can file a joint manifestation in court that you're agreeing that service between parties will have to be done electronically. Joint manifestation, you are correct. Okay. Okay. Presumptive service. There shall be presumptive notice to a party of a court setting if such notice appears on the records to have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, or at least 30 calendar days if the addressee is from outside the judicial region. Okay, so that's a new provision. Let me just explain it. Okay, minsan in practice, okay, so I received, let's say, an order from the court. Lalo na ngayon, maraming cancellations sa court because of COVID. So, hindi naman kami nag-agree kung kailan yung hearing. So, hihintayin namin yung court, sasabihin sa amin, kailan yung setting kasi na-cancel nga because of COVID. So, nakatanggap ngayon ako, let's say, ng hearing, let's say, ng order from the court. Ang hearing daw namin is July 1. Okay. The court, let's say, is in Makati, RTC Makati. Ako, Makati. Kalaban ko, Makati. Okay. Pumunta ngayon ako ng July 1. Okay, pumunta ako ng July 1. And then, the first thing I will do is go to the staff of the court and will ask for the record so that I will check kung notified ba yung kalaban ko o hindi. Okay. And if I see that there's a return that says, okay, na-serve, okay, it says here that it appears from the records of the case that it has been mailed, okay, to my opposing counsel who is in Makati within at least 20 days prior July 1, okay, pag-appear ko sa korte at hindi dumadating yung kalaban ko, pwede kong sabihin lalo kung bit-bit ko yung witness, no? Pwede kong sabihin sa korte, Your Honor, may I request that I be allowed to present my witness because under Section 10 of the rule, okay, there is now a presumptive service of the hearing of the order setting the hearing today. Why? Because my opposing counsel, okay, it's shown that it was served 20 days prior to the scheduled date of hearing. And considering that the counsel, okay, is also within the same judicial region, holds office in the same judicial region where the court sits, okay, then may I be allowed to present my witness. That is presumptive service. Pero paano kunwari, ang kalaban ko nakatira sa Baguio, okay, ang Baguio hindi naman yan National Capital Judicial Region. Sa pagkaalam ko, it's the first judicial region. For the presumption to arise, okay, for me to be able to invoke presumptive service under Section 10, the order should have been mailed at least 30 calendar days if the addressee is from outside the judicial region. Okay. Again, this is very consistent with the reason, okay, behind the amendment to ensure that there will be no delay. Okay? Kaya merong itong presumptive service. Okay. Section 11. Okay. A party who changes his or her electronic mail address or facsimile number while the action is pending must promptly file within 5 calendar days from such change a notice of change of email address or facsimile number with the court and serve the notice on all parties. Service through electronic mail or facsimile number of a party shall be presumed valid unless such party notifies the court of any change as aforementioned. So like a change of address, you move your law office, you have to inform the court of your change of address. Okay. Is that clear? Okay. Section 12. Electronic mail and facsimile subject and title of pleadings and other documents. The subject of electronic mail and facsimile must follow the prescribed form or format. Case number, case title, and the pleading order or document title. The title of each electronically filed or served pleading or other document and each submission served by the facsimile shall contain sufficient information to enable the court to ascertain from the title the party or the parties filing or serving the paper, the nature of the paper, the party or parties against whom relief, if any, is sought, and the nature of the relief sought. In fact, my question is this: how do we do if we want to file electronically, let's say a reply, okay? Pag final yung reply, pwede ba, and then wala akong i-deny under oath. So walang kailangan yung denial under oath. Hindi pala ako pwede mag-file ng reply pala na. Kunwari, I will file, let's say, a memorandum, okay? I will file a memorandum. Pwede ba yung memorandum, yun i-type ko na doon sa electronically, doon sa mismong email, doon. I will follow everything, from the caption to everything. Doon ko na kaagad ita-type. Or is it going to be by way of attachment? Okay. One thing for sure, okay, one thing I'm sure is this, okay? What is required is an sufficient information. The nature of the paper, the party or parties against whom relief, if any, is sought, and the nature of the relief sought. Okay. You know, it just by way of comment, because of this, of the amendments introduced by the 2019 rules, hindi lang, it's not only civil procedure, the teaching of civil procedure that will be affected, even the pleading, even the forms, yung hindi na tayo magpo-comply na ngayon sa ultimate facts, may evidentiary facts, at dapat kasama na doon yung judicial affidavits. Okay. Now, service of judgments, final orders, or resolution. Okay. Okay. Judgments, final orders, or resolutions, okay, shall be served either personally or by registered mail. Ex parte motion of any party in the case, a copy of the judgment, final order, or resolution may be delivered by accredited courier at the expense of such. When a party summoned by publication has failed to appear in the action, judgments, final orders, or resolutions against him or her shall be served upon him or her also by means of publication at the expense of the prevailing party. So how do you serve, or what are the different modes of serving judgments and final orders or final resolutions? Personal service. Number 2, registered mail. Number 3, publication, if summons was served through publication. And number 4, upon the filing of an ex parte motion and the same being approved by the court, it can be served through an accredited private courier upon, of course, prior court approval and payment by the movant of the expenses to be incurred to effect the same. So I think it is quite clear from Section 13 that you cannot serve, okay, final judgments, final orders, or final resolutions via ordinary mail. Kung sinerve mo via ordinary mail yan, dapat hindi aandar ang bilang to file an appeal. Kasi hindi naman siya mode of serving judgments or final orders. Okay. Now, Section 14. Okay, if you read Section 14, okay, notwithstanding the foregoing, the following orders, pleadings, and other documents must be served or filed personally or by registered mail when allowed, and shall not be served or filed electronically unless the permission is granted by the court. Okay? Kaya kanina may nagtatanong, paano yung filing ng complaint? Can it be done electronically? Okay. Initiatory pleadings and initial responsive pleadings such as an answer, as a general rule, can only be filed personally or by registered mail. Okay? It is only when it's allowed by the court that it can be filed electronically. Subpoena, okay, cannot be served electronically. Protection orders, PPOs, or writs of preliminary attachment, writs or writ of temporary restraining order, writ of preliminary injunction, okay, must be served personally or by registered mail, can be served only electronically if approved by the court. Appendices and exhibits to motions or other documents that are not readily amenable to electronic scanning may, at the option of the party filing such, be filed and served conventionally, and sealed and confidential documents or records. That's a new provision. Okay. Now, somebody asked, how do you authenticate signature of counsel party if filed by electronic means? I think that's a reason why if I were to file a pleading by electronically, I would make it by way of attachment. Okay? I-scan ko na lang yan. Okay? Para ma-scan din yung signature ko, yun ang ipa-file. Okay. Now, Section 15, completeness of service. Okay, let me just present it in summarized form. Okay. How will personal service? Okay, personal service is deemed complete upon the actual receipt. Okay, actual receipt. How about ordinary mail? Completeness of ordinary mail upon the expiration of 10 calendar days after mailing, unless the court provides otherwise. How about registered mail? Upon actual receipt by the addressee or other, or after 5 days, okay, from the date he or she received the first notice of the postmaster, whichever date is earlier. And then your accredited private courier service is by accredited courier is complete upon actual receipt by the addressee, okay, or at least 2 attempts to deliver by the courier service or upon the expiration of 5 calendar days after the first attempt to deliver, whichever is earlier. Okay. So, okay, and then of course, electronic service at the time of the electronic transmission of the document or when available at the time the electronic notification of service of the document is sent. So dapat, as I said, yung pinaka-sent button mo, kung ano nakalagay dun sa sent box. Electronic service is not effective or complete if the party serving the document learns that it did not reach the person to be addressee or person to be served. And then facsimile upon receipt by the party as indicated in the facsimile transmission printout. Pag serve mo kasi niya, pagpadala mo, may lalabas na printout eh. That will be the evidence to show when it was really sent by facsimile transmission. Let me just go back to accredited private courier. Okay. Service to the other party, no, by accredited courier is complete upon actual receipt of the address. Because sinerve sa akin ng LBC, which is LBC, let's assume is an accredited courier. Not sinerve sa akin, kunwari, pinadala ng November 5. Pero natanggap ko November 6. Serve sa akin yun November 6 kasi is complete upon actual receipt by the addressee. Or after at least 2 attempts to deliver by the courier service or upon the expiration of 5 calendar days after the first attempt to deliver, whichever is earlier. Okay. Let me just go back to registered mail. Okay. And it is reckoned from the first notice. So if I received, let's say, a first notice in December 1, I went to the post office to claim it December 3. It was deemed served upon me December 3. I went to the post office December 5. After I received the first notice December 1, deemed received ko yan December 5. But if I went to the post office December 7, okay, I received the first notice December 1, I am deemed, under the law, deemed to have been served December 6, kasi 5 days from December 1. Okay. Okay, now, Proof of filing, okay. When you file a complaint, let's say you file a pleading in court, you file your answer. What is the best proof, okay, that it was filed? Sabi ng first paragraph, proof of filing of the pleading is proven by the existence of it in the records of the court's folder. So, ang best proof na na-file mo yan, nasa court folder. Paano kung wala? Okay. What if the pleading is not in the court records, but you now claim that that you claim to have filed it? The proof now will depend upon the mode of filing. If personal service, what will be your proof? It is proven by the written or stamped acknowledgement of its filing by the clerk of court on a copy of the pleading or court submission. Kasi pag nagpa-file ka, yung kopya mo, dapat may tatak din ng clerk na tumanggap, no? Yan ang magiging pruweba mo. How about if you filed it by registered mail? The filing shall be proven by the registry receipt, by the affidavit of the person who mailed it, containing a full statement of the date, place, and deposit of the mail in the post office in a sealed envelope addressed to the court, with postage fully prepaid and with instructions to the postmaster to return the mail to the sender after 10 calendar days if not delivered. 3. Okay? Kung paano kung final mo by you claim, final mo and you filed it via accredited private courier, pero pagdating mo sa records of case, wala doon yung pleading. How will you prove that you filed the pleading by accredited private courier? The filing shall be proven by an affidavit of the person who brought the pleading, okay, or other document to the service provider together with the courier's official receipt and the document tracking number. Kaya wag iwawala yung tracking number. Okay. Again, another situation. You claim that you have filed it electronically, pero pagtingin sa records ni judge, wala dun yung pleading. So it is now incumbent upon you that you really filed it electronically. So, how can you prove that it was filed through authorized electronic means? It shall be proven by an affidavit of electronic filing of the party accompanied by a copy of the electronic acknowledgement of its filing by the court. Okay, in other words, kung sino yung gumawa nun, magawa ng affidavit at magkalakip ng kopya. Okay? Papatunay to support the representations made by the person who prepared the affidavit. Okay. Proof of service of pleading. Okay, pinag-usapan natin kanina, proof of filing. Now we're going to discuss proof of service of pleading. Okay. If the pleading was sent by ordinary mail, an affidavit of the person mailing stating the fact showing compliance with Section 7 of this rule. Now, a written admission of the party served or the official return of the service or the affidavit of the party serving containing a statement of the date, place, and manner of service. If the pleading was served read by registered mail, again, another affidavit. The registry receipt issued by the mailing office. The registry return card shall be filed immediately upon its receipt by the sender or in lieu thereof, the unclaimed letter together with a certified or sworn copy of the notice given by the postmaster to the addressee. By accredited private courier, how will you prove the service? Okay, if you did it by private courier. Affidavit of service executed by the person who brought the pleading or paper to the service provider together with the courier's official receipt and the document tracking number. And by electronic mail or facsimile, the affidavit of the person who sent the email. Okay? Kung sino yung pumindot, siya ang gagawa ng affidavit of service or yung gumawa ng cause the electronic transmission together with a printed proof of transmittal. Okay. Look at your section 18. It says, the court may electronically serve orders and other documents to all parties in the case which shall have the same effect and validity as provided herein. Okay. A paper copy of the order or other document electronically served shall be retained and attached to the record of the case. Now I have a question. Okay. You read section 18. in relation to Section 13. Okay? Section 13 under the 2019 rules specifically provides service of judgments, final orders, or resolutions can be served either personally, electronically, or upon approval of the court, okay, can be served through accredited courier. The Section 18 now allows, okay, that service be done of judgments, final orders, can it be done electronically? Okay. This is my personal opinion, okay? I don't think so. When it comes to service of judgments, final orders, or resolutions, okay, I think it can only be served pursuant to Section 13 because it specifically addresses final orders, or final resolutions, or judgments. It can only be served personally by registered mail or if allowed by the court, yan, pwede yan by authorized private courier. Or if summons was served, okay, by publication and then publication. But when it comes to others, okay, it cannot be served electronically. Okay. If a motion to dismiss was denied, okay, that is an interlocutory order. That is not a final order. Now, if the court allows it, that order denying the motion to dismiss can be electronically served. Okay? Now, on the other hand, if, for example, if the motion to dismiss has been granted, that's a final order. Why? Because nothing else, okay, will have to be done by the court. Can it be served electronically? With all due respect, I think Section 13 should prevail. Okay, notice of lis pendens, which is under Section 19, walang pagbabago. Section 1, clerk to issue summons. Okay, unless the complaint is on its face dismissible under Section 1, Rule 9, the court shall, within 5 calendar days from receipt of the initiatory pleading and proof of payment of the requisite legal fees, direct the clerk of court to issue the corresponding summons to the defendants. Okay, just by way of recall, the principle is jurisdiction over the defendant is acquired either upon valid service of summons or the defendant's voluntary appearance in court. When the defendant does not voluntarily submit to the court's jurisdiction, or where there is no valid service of summons, any judgment of the court which has no jurisdiction over the person of the defendant is null and void. And that's the case of Manotoc versus Court of Appeals, a 2006 case. No summons, if you will notice in Section 1, no summons will issue if the court, motu proprio, decides to dismiss the complaint on any of the following grounds. Number 1, no jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. And that's pursuant to Section 1 of Rule 9. Okay. Now, the courts now, under the proposed rule, is given a period of 5 days, okay, from receipt of the initiatory pleading with proof of payment of the required docket fees to cause the issuance of the summons. Now, summons, the service of summons is a valid and a vital, rather, and indispensable ingredient of due process. As a rule, if defendants have not been validly served, the court acquires no jurisdiction over the person, and a judgment rendered against them is null and void. Chu versus Mac Asia. Okay. Now, what happens if the court, okay, if there was improper service of summons? What will be the remedy of the defendant? Please, defendant, do not file a motion to dismiss because it's no longer allowed, okay? What you should do is the ground should be raised as an affirmative defense in the answer, pursuant to Section 12(1), Rule 8 of the 2019 rules, okay? The court shall thereafter resolve motu proprio the said affirmative defense within 30 calendar days from the filing of the answers, basis Section 12B, Rule 8 of 2019 rules, okay? Now, what happens if the affirmative defense is denied? Okay, again, pursuant to Section 12, Rule 8, It shall not be subject to a motion for reconsideration, which means you cannot file a motion for reconsideration against the order denying that affirmative defense. Or it cannot even be subject, of course, a petition for certiorari, prohibition, or mandamus. You cannot even appeal that because that's an interlocutory order. So what is the proper remedy now of the defendant? Go to trial. And in the event of an adverse judgment, appeal the judgment and raise the order of denial as one of the assigned errors. And that is pursuant to Section 12D, okay, Rule 8 of the 2019 rules. Okay. Now we go to the contents. Section 2. The summons shall be directed to the defendant, signed by the clerk of court under seal, and contain the following. Okay. The name of the court and the name of the parties to the action. And listen to this, and this is you. When authorized by the court upon ex parte motion, an authorization for the plaintiff to serve summons to the defendant. C, a direction that the defendant answer within the time fixed by the rules. And D, a notice that unless defendant so answers, plaintiffs will take judgment by default and may be granted the relief applied for. A copy of the complaint and order for appointment of the guardian ad litem, if any, shall be attached to the original and each copy of the summons. So it is clear from Section 2 that the substantial amendment to Section 2 is in paragraph D. If the court authorizes the plaintiff to serve summons, then the plaintiff may serve summons, but that should be stated in the summons itself. Now, the court may issue authorization upon ex parte motion also for the plaintiff to serve summons via electronic service, which we will discuss later. Now, let's go to Section 3. The summons may be served by the sheriff, his or her deputy, or other proper court officer, and in case of failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. In cases where the summons is to be served outside the judicial region of the court where the case is pending, the plaintiff shall be authorized to cause the service of summons. If the plaintiff is a juridical entity, it shall notify the court in writing the name and its authorized representative therein, attaching a board dress or sex cert thereto, as the case may be, stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. If the plaintiff misrepresents that the defendant was served summons and it is later proved that no summons was served, the case shall be dismissed with prejudice, the proceedings shall be nullified, and the plaintiff shall be meted appropriate sanctions. If summons is returned without being served on any or all the defendants, the court shall order the plaintiff to cause the service of summons by other means available under the rules. Failure to comply with the order shall cause the dismissal of the initiatory complaint without prejudice. Okay. So, Section 3, I think, must likewise be read in conjunction with Section 2. The plaintiff may be authorized to serve the summons in the following cases. Number 1, in cases where there is failure to serve summons by the sheriff, okay, the court may authorize the plaintiff to serve the summons together with the court sheriff. Hindi mag-iisa si plaintiff. Number 2, the court can likewise authorize the plaintiff to serve the summons in cases where the summons is to be served outside the judicial region of the court where the case is pending. Okay. Notice, however, there is nothing in that particular situation that says that the court sheriff should accompany the plaintiff in serving the summons outside, okay, the judicial region of the court. You know, I think only because the sheriff, okay, of that court cannot really, has no authority to go outside the region. So I think pragmatically speaking, the plaintiff should coordinate, okay, with the sheriff of that judicial region, okay, so that when he when he serves the summons to the defendant, at least may kasama siya namang sheriff, hindi siya nag-iisa. Okay? Now, If the plaintiff is a juridical entity, of course, the person who will represent the plaintiff must be armed, okay, with a special power of attorney, director's certificate, or secretary's certificate, okay? Now, if the plaintiff misrepresents, this is to avoid, let's say, abuse, no? Wherein the plaintiff will be authorized by the court to serve. Para naman tiyak, gagawin talaga ni plaintiff yung inatasan sa kanya. If the plaintiff misrepresents the defendant was served summons, what will happen? Number one, the case will be dismissed with prejudice. Okay, the proceedings will be nullified. The first will be subjected to appropriate sanctions. If summons now is returned unserved, the court shall order the plaintiff to cause the service of summons by other means, such as by what? Publication. Failure to comply with the order of the court shall cause the dismissal of the initiatory pleading, such as, of course, your initiatory pleading can be the complaint, the third-party complaint, without prejudice. Notice, may order yung court. Okay, the plaintiff was not able to serve the summons, and then the court now will issue an order saying, "O plaintiff, cause the service of summons through other means authorized by the court." And then the plaintiff did not comply. It is clear from Section 3, okay, Section 3, that the complaint will be dismissed, but without prejudice. This, I think, is an exception to the rule mentioned under Rule 17, Section 3, that if you fail to obey the order of the court and you become, of course, a disobedient party, then the complaint will be dismissed with prejudice. Pero ito, exception sa rule. Kasi very clear from Section 3, even if you did not follow the court order, okay, the complaint will be dismissed, but this time without prejudice. Okay. Validity of summons and issuance of alias summons, Section 4. Okay. Summons will remain valid until duly served. So, walang lifetime, di ba? Okay. Unless it is recalled by the court. In case of loss or destruction of summons, the court may, upon motion, and that is going to be an ex parte motion, can issue an alias summons. So summons will remain valid until it is what? Recalled, destroyed, or lost. Remedy, if you want another summons, you have to ask the court, go to court and ask the court to issue an alias summons. An alias summons is merely a continuation of the original summons. And that is a ruling in the case of Philippine American Life and General Insurance versus Breva. Okay, now, Section 5. Whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served, or if he or she refuses to receive and sign for it, by leaving the summons within the view and in the presence of the defendant. Okay. Jurisdiction over a defendant in a civil case is acquired either through service of summons or through voluntary appearance in court and submission of the defendant to the authority of the court. In the absence of service, or when the service of summons upon the person of the defendant is defective, the court acquires no jurisdiction over his person, and judgment rendered against him is null and void. 2018 case of Interlink Movie House versus CA. Now, how do you serve summons? Okay, first, personal service is effected by handing a copy of the summons to the defendant himself in person. Now, if the defendant refuses to receive and sign for it, then tender it. That is equivalent to personal service. Now, there is one case, and this is the case of Sancho, Philippines versus Spouses Mogul. It's a 2009 case. So in this particular case, Sancho actually filed two cases against Spouses Mogul. Okay, one criminal, one civil. Now, in the civil case, the summons could not be served at the residence of Spouses Mogul. Pumupunta si sheriff, hindi dumadating doon. Wala yung Spouses Mogul. Okay. So what happened was Sancho told the sheriff, anyway, sheriff, we're going to have a hearing on this day. in our criminal case, and we are very sure that spouses mogul will be there. So kindly serve, okay, the summons to the defendants there in court where we're having our criminal case heard. So that's what happened. The sheriff went there, nakita niya ngayon si spouses mogul, binigay niya ngayon yung summons and yung copy of the complaint. Now the defendants, what did the defendants do? The defendants now gave the copy of the complaint to their lawyer. Binasa ngayon ng lawyer. Sabi ng lawyer, oh, ang nakalagay naman sa complaint, serve the complaint and the summons, okay, at the residence. Di ba may paragraph doon sa complaint na defendant is of legal age, married, o ganyan, and a resident of blah, blah, blah. Summons addressed to the defendant may be served at the address indicated above. So sabi ng abogado, oh, malinaw na nakalagay dito sa complaint. You have to serve the summons, okay, to the residence of the defendant. So hindi tinanggap ni spouses mogul. So anong ginawa ni sheriff? Iniwan. Okay, iniwan. So what happened in that particular case? Was the court able to acquire jurisdiction over the person of the spouses? Okay. According to the Supreme Court, okay, respondent spouses mogul principally argued that Section 6 of Rule 14 cannot be singled out without construing the same with Section 7. They posit that in a civil case, summons must be served upon the defendants personally at the designated place alleged in the complaint. That was the position taken by the lawyer of spouses mogul, and of course, they followed, no? If the defendants refuse to receive and sign the summons, then the process server must tender the same to them by leaving a copy at the residence of the defendants. If the summons cannot be served in person because of the absence of the defendants at the address stated, then the same can be served by leaving copies of the summons at the defendant's residence with some persons of suitable age and discretion residing therein, or by leaving the copies at defendant's office at a regular place of business with some competent person in charge thereof. Now, according to the Supreme Court, regardless, okay, regardless, the fact is, nakita na niya si defendant and the sheriff tendered it, okay? Now, that means when the sheriff tendered it, okay, that was now proper service of summons. So, miski saan ka makita, pag nakita ka ng sheriff at ikaw nga yung defendant, pwedeng ibigay sa yan miski saan. Ngayon, kung hindi mo yan tinanggap, tama yung ginawa ni sheriff, tinender niya. So the court was able to acquire jurisdiction over the person of defendant spouses. Okay, now, in section, now we go now to section, we're done with section 5, now we go to section 6, substituted service. If for justifiable causes, the defendant cannot be served personally after at least 3 attempts, on 2 different dates, service may be effected by leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient discretion residing therein, by leaving copies of summons at the defendant's office or regular place of business with some competent person in charge thereof. A competent person includes but is not limited to one who customarily receives correspondences for the defendant, by leaving copies of the summons if refused entry upon making his or her authority and purpose known with any of the officers of the homeowners association or condominium corporation or its chief security officer in charge of the community or the building where the defendant may be found. Okay? By sending, okay, just 1 minute please. By sending an electronic mail to the defendant's electronic mail address if allowed by the court. Okay, now, let us now talk about section 6 because this section 6 is talagang new. Okay? Now, section 6 basically incorporates decisions already of the Supreme Court. Okay? Now, regardless of what type of action, whether it's in personam, in rem, quasi in rem, the preferred mode of service is personal. Now, to avail themselves of substituted service, courts must rely on a detailed enumeration of the sheriff's action and a showing that the defendant cannot be served despite diligent and reasonable efforts. Okay. The sheriff's return, which contains these details, is entitled to a presumption of regularity. And on this basis, the sheriff may allow substituted service. Should the sheriff's return be wanting of these details, substituted service will be irregular if no other evidence of the efforts to serve summons was presented. Failure to serve summons will mean that the court failed to acquire jurisdiction, okay, over the person of the defendant. Okay. Now, and that's the case of the Pedro versus Romasana 2014 case. Now, for the presumption of regularity to be applied on a sheriff's return, the sheriff's return must contain the following. Number one, detailed circumstances surrounding the sheriff's attempt to serve the summons on the defendant. Two, the specifics showing impossibility of service within a reasonable time. And now, based on this requirement, okay, then the sheriff's return will not be considered pro forma. That's according to the case of Philippine People's General Insurance Corp versus Guansing, a 2018 case. Now, the following requisites must therefore be observed in order that substituted service of summons could be considered valid. And this is pursuant to the case of Manoto, okay, versus Court of Appeals. Okay. Now, the first requirement, okay, impossibility of prompt personal service. Okay. Ano ba yung prompt personal service? Ano, how would you, several attempts means at least 3 tries, preferably on at least 3 different dates. So, pwedeng Monday, umaga, hapon. And then Wednesday, umaga. 2 different dates, 3 occasions. Okay. Number 2 requirement, specific details in the return. The sheriff must describe in the return of summons the facts and circumstances surrounding the attempted personal service. Hindi pwedeng nakalagay lang, nasan si defendant yan? Wala po. Okay, bye-bye. Hindi sufficient yon. The efforts made to find the defendant and the reasons behind the failure must be clearly stated in the detail in the return. The date, the time of the attempts on personal service, the inquiries made to locate the defendant, the name of the occupants of the alleged residence or the house of the defendant, and all other acts, though futile, to serve summons on the defendant must be specified in the return. Okay? Just to precisely show the impossibility of prompt service, okay, at saka yung efforts made to find the defendant and the failure of said efforts. Now, third, the return must likewise show the name of the person of suitable age and discretion. Okay? And remember in the case of Johnson versus Dumagas, dapat yung pinag-iwanan mo ng dokumento kung isinerve mo sa bahay, okay, dapat yan is a resident. Therefore, kunwari, nadaan lang na, in the case of Johnson, kapatid, dumaan lang, nangolekta lang kasi ng renta, doon ibinigay yung summons. Improper yon. Okay? Because the requirement is the person to whom the summons will be given, okay, in cases of substituted service of summons, and you serve it in the house, must be of suitable age, discretion, and a resident therein. Okay. Now, paano kung sa office? Okay. Kung kunwari binigay sa office. Let's first recall the ruling in the case of Sandoval versus HRET. Of course, the same thing, no? Kung ano yung mga attempts at saka ganyan. Pero pag sa office, dapat ibibigay mo sa isang taong competent person in charge. And what do you mean by competent person in charge? Now, in the case of Sandoval versus HRET, which is a 2002 case, to be a competent person, the person to receive someone means that he should be duly qualified and must have the following: sufficient capacity, ability, or authority. There should be a relation of confidence between the person who received the summons and the defendant. Okay. Ang nangyari kasi dito sa Sandoval versus HRET, isang utility man ang pinagbigyan. So sabi ng Supreme Court, improper yung service na yan kasi yung utility man, hindi naman, unang-una, hindi naman talaga siya employee dun sa office ni Congressman Sandoval. Tapos, well, yun nga, cannot be considered a person of competent authority, he cannot be considered a competent person because he does not have a relation of confidence with Congressman Sandoval. Okay. Now, Section 7. Service upon entity without juridical personality. Okay. When persons associated in an entity without juridical personality are sued under the name by which they are generally or commonly known, service may be effected upon all defendants by serving upon any one of them or upon the person in charge of the office or place of business maintained in such name, but such service shall not bind individually any person whose connection with the entity has upon due notice, okay, been severed before the action was filed. Ito, hindi ito na bago. Remember, only persons who are natural, juridical, and those persons authorized by law can sue. But even if you are not an organized, okay, or an incorporated entity, but you represented yourself to be an incorporated entity, you can be sued. At kanino isa-serve ang summons pag yun? If you're a juridical and you're an entity without a juridical personality, ibibigay, summons may be effected. Okay, summons may be effected, okay? May be effected upon all the defendants by serving upon any one of them or upon the person in charge of the office or place of business maintained in such name. Okay. Paano kung ang dinimanda natin is single proprietorship? Aling Nenes Carinderia. Okay? Kanino isa-serve? Siyempre, si Aling Nenes Carinderia, pag single proprietorship yan, does not possess a juridical personality separate and distinct from the owner. Okay? The law does not vest a separate legal entity on sole proprietorship or empower it to file or defend an action in court. Remember, only natural, juridical persons or entities authorized by law may be parties to a civil action. Kaya sa kaso ni Ejercito versus M.R. Vargas Court, 2008 case, if it's a single proprietorship, kanina isa-serve ang summons dun sa may-ari. Okay? Dun sa proprietor. Okay. Section 8. When the defendant is a prisoner, confined in a jail or institution, service shall be effected by him or her by the officer having the management of such jail or institution who is deemed as the special sheriff for that purpose. Okay. The jail warden shall file a return within 5 calendar days from service of summons to the defendant. It is not the court sheriff that will hand over the summons and the complaint to the inmate defendant. It will be the jail warden. Okay. Palagay nyo ba magkakaroon ng substituted service dyan kung hindi mahanap si defendant? Siyempre hindi, kasi ibig sabihin nun, nakatakas si defendant, di ba? Kaya personal service yan. Now, if si jail warden ang nagbigay kay defendant ng summons at saka ng complaint, then it is the jail warden who will execute, okay, the sheriff's return. Okay, is that clear? Okay. Now we go to Section 9. Service may be made through methods which are consistent with established international conventions to which the Philippines is a party. Okay. Now, ang importante lang dyan sa convention na yan, dapat signatory ang Philippines. Okay. Now, Section 10, service upon minors and incompetents. Okay. Section 10, let me just summarize it. Service must be made on the minor and his parent or legal guardian. You just still have to serve it to the minor and then the parent. Insane or incompetent, if they're sued, you serve it on the insane or incompetent and his guardian ad litem. Paano kung wala siyang guardian ad litem? Okay. The plaintiff need not institute a separate action for the appointment of a guardian ad litem. The plaintiff can secure the appointment in the said case. Okay. Now, Section 11. When spouses are sued jointly, service of summons should be made to each spouse individually. I think this is very correct. Okay, very correct. The sheriff cannot, on the first attempt to serve the summons to the wife, just leave it to the husband. Husband and wife dinimanda, first attempt pa lang ni sheriff, binigay niya yung summons sa asawa na lalaki kay husband, and then kay wife, iniwan niya kaagad kay husband. That cannot be. That would be improper substituted service of summons. Dapat is-serve din niya personally dun sa wife. It is only in the event that, you know, there's failure to serve personally that you can effect substituted service of summons. Okay. Now, Section 12. When the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, okay, managing partner, general manager, corporate secretary, treasurer, or in-house counsel of the corporation, wherever they may be found, or in their absence or unavailability, okay, under secretaries. If such service cannot be made upon any of the foregoing persons, it shall be made upon the person who customarily receives the correspondence for the defendant at its principal office. Okay. In case the domestic juridical entity is under receivership or liquidation, service of the summons shall be made on the receiver or liquidator as the case may be. Should there be a refusal on the part of the persons above mentioned to serve summons despite at least 3 attempts on 2 different dates, service may be made electronically if allowed by the court as provided under Section 6. Okay, let me now discuss this. Okay, the amended provision, Section 12, no longer restricts and limits the service of summons to domestic private juridical entities to the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel. So therefore, the oft-repeated ruling no longer applies. Diba? May ruling kasi noon ang court as held in the case of Green Star Inc., Express Inc. versus Nissan Universal Robina Court. Ito hindi na nag-a-apply. That the rule now states general manager instead of manager, corporate secretary instead of merely secretary, and treasurer instead of cashier. It has now become restricted, limited, and exclusive only to persons enumerated in the aforementioned provision. It is exclusive. Hindi na yan nag-a-apply. Why? Because aside from those officers mentioned in the first paragraph, sabi ng rule, okay, in their absence or unavailability of the foregoing corporate officers, kung hindi daw, wala daw, unavailable si president, si managing partner, general manager, corporate secretary, treasurer on in-house, okay, you can serve it on their respective secretaries. Okay. Pero notice, okay, wala namang sinabi sa batas, okay, that the service to the secretaries is subject to the requirement that the summons was attempted to be served at least 3 attempts on 2 different occasions. Walang sinabing ganon. Okay? So, in my personal opinion, okay, pag pumunta ka sa presidente, let's say Monday, wala. Okay? Wala rin yung managing partner, wala rin si general manager or si corporate secretary. Sa susunod magbalik mo, pag wala, pwede mo nang, at wala pa rin, pwede mo nang iwanan sa sekretarya. Pangalawa, dapat ba lahat i-serve mo muna doon sa president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel? Walang sinabing ganong requirement. Ang sinabi lang, in the absence or unavailability of the foregoing corporate officers, summons can be served on their secretaries. Okay. Third point. If such service cannot be made on those corporate officers, okay, and cannot be served on their secretaries, pati yung secretaries nila unavailable. Okay. The summons can be served upon persons who customarily receives the correspondence for the defendant at its principal office, yung receiving clerk. Again, walang requirement na sinasaad ng batas that service to the person who customarily receives those documents is subject to the requirement that there should be first that the summons was attempted to be served at least 3 times, okay, 3 attempts on 2 different dates. Wala ring sinabi. So kung hindi mo ma-serve sa corporate officers, sa secretariats, kung hindi mo ma-serve sa secretariats kasi unavailable sila, sinong pupuntahan mo? Yung custodian who customarily receives the correspondence for the defendant at its principal office. Okay? At its principal office. Hindi dun sa kunwari, sa branch. Okay? Hindi pwede sa branch. Dun sa principal office. Now, in case a domestic corporation is under receivership or liquidation, okay, kanino mo isuserve ang summons? Sa liquidator o sa rehabilitation receiver. Okay? At mas tama nga naman yun. Okay, now. So, service of summons, binabanggit din dito that service of summons through electronic means can be resorted to but subject to the following conditions. Okay? Service of summons through electronic means can be resorted to when the summons to the following persons could not be served at least 3 attempts on 2 different dates to the following person. Yan yung may 3 attempts on 2 different dates. Yan ngayon yung may requirement. If you cannot serve it on 3 attempts on 2 different dates to the president, managing partner, general manager, corporate secretary, treasurer, or in-house, the respective secretaries, or the person customarily authorized to receive the documents or kung under receivership sa receiver or under liquidation sa liquidator, okay? Kanino mo nga, you just have to go to court and ask the court to allow you to serve summons by electronic means, okay? As provided, okay, under Section 6. Is that clear? Section 13 is new, very short. When the summons is improperly served and a lawyer makes a special appearance on behalf of the defendant to, among others, question the validity of service of summons, the counsel shall be deputized by the court to serve summons on his or her client. Anong ibig sabihin? Okay. Kunwari naka-receive ako, kunwari ako yung lawyer ng defendant. And let's assume nag-substituted service of summons. Not in accordance with the rule, not in accordance with Manoto. First time lang, sinerve na by substituted means. E dun sa complaint, may prayer for, let's say, TRO. You know, pag may prayer ng TRO, ibig sabihin, or a writ of preliminary injunction, may a-appear ka na kaagad sa korte, hindi pa natatapos yung period to file an answer. Uma-appear ka na sa korte kasi pag-aawayan nyo na yung TRO eh. Siyempre, pag umappear ka ngayon sa TRO, sasabihin mo na immediately pa lang para sasabihin hindi ma-consider as voluntary submission to the court's jurisdiction. You will say, I'm entering my appearance here as and by way of a special appearance without prejudice to the right of the defendant to question the impropriety of the service of summons. Okay, sinasabi mo, kasi improper yung service of summons. So I'm just appearing here because of the TRO hearing, but this is without, okay, without me submitting to the jurisdiction of the court and waiving the impropriety of service of summons. Di sinabi mo yun. Anong gagawin ngayon ng judge? Pursuant to Section 13.7, ganon, your special appearance. O sige, I'm now deputizing you to serve the summons to your client. And of course, as an officer of the court, I have no choice but to follow the court. And I will now be the one who was deputized to serve the summons to my client. Is that clear? Okay, that is Section 13. Okay. Now, Section 14. Okay, notice, nung binasa natin 1 to 13, depende pa paano i-serve yung summons, depende kung anong klase, okay, yung defendant. Sabi ko nga nung last Monday, you know, you just have to classify. Okay, natural, juridical, domestic. Now we go to foreign. Okay. Service upon foreign private juridical entities. When the defendant is a foreign private juridical entity which is transacted or is doing business in the Philippines as defined by law, service may be made on its resident agent designated in accordance with law for that purpose, or if there be no such agent on the government official designated by law to that effect, or any of its officers, agents, directors of justice within the Philippines. Okay. If the foreign private juridical entity is not registered in the Philippines or has no resident agent but has transacted or is doing business in the Philippines as defined by law, such service may, with leave of court, be effected outside of the Philippines through any of the following means: by personal service, course through the appropriate court in the foreign country with the assistance of the DFA, by publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of summons and the court order by registered mail at least at the last known address of the defendant, by facsimile, by electronic means with the prescribed proof of service, or by such other means as the court in its discretion may direct. Okay. Now, notice that in section 14, service of summons, okay, to foreign private juridical entities is served in different ways depending on where is the foreign private juridical entity. Okay. If the foreign private juridical entity has transacted or is doing business in the Philippines, okay, as defined by law, okay, you can serve it on the resident agent. Lalo na kung yan ay rehistrado, has a permit to do or license to do business in the Philippines. May resident agent yan. I-serve nyo muna sa resident agent. Ngayon, kung walang resident agent, kunwari namatay si resident agent, hindi pa napalitan. So wala siyang resident agent. But the corporation is doing business in the Philippines, kanino mo ngayon isa-serve yung summons? The government official designated by law to receive summons if the corporation does not have a resident agent. Okay. Or, pwede mo rin niyang iserve sa officers, agents, directors, or trustees who are in the Philippines. Okay. Now, on the other hand, if that foreign private juridical entity is not registered in the Philippines or has no resident agent but has transacted or is doing business in the Philippines, okay, such service may, with leave of court, okay, be effected outside the Philippines. Basta lumabas ka ng Pilipinas, with leave of court yan. And paano isa-serve? Okay, number one, personal service, but you have to course it through the DFA. Okay, number two, publication once in a newspaper of general circulation in the country where the defendant may be found, and by serving a copy of the summons and the court order by registered mail at the last known address of the defendant. Pangatlo, you can serve summons to this type of foreign private juridical entity through facsimile machine or by electronic means with the prescribed proof, or by such other means as the court in its discretion may direct. Okay. Please take note that for the purpose of acquiring jurisdiction by way of summons on a defendant that is a foreign corporation, there is no need to prove that there's no need to prove first the fact that the defendant is doing business in the Philippines. The plaintiff only has to allege that in the complaint, okay? And that's it. That is the only requirement, okay, to determine whether this provision will apply. Avon Fit Insurance PLC versus CA. Now, service upon public corporation. Let me now summarize it. If the defendant public corporation is the Republic of the Philippines, kanino isa-serve ang summons? Solicitor General. If the defendant public corporation is the province, kanino isa-serve? Sa governor. If the defendant, let's say, is the city, kanino isa-serve yung summons? The mayor. Kung sa municipality ang kalaban mo, kanino mo isa-serve yung summons? Sa mayor. E paano kung ang barangay ang kalaban? Hindi sa barangay captain, sa mayor. Kasi ano naman yun a component naman ng barangay, ng city, a component ang barangay. So the executive officer still will be the mayor. Okay. Now, Section 16, okay? Service upon defendant whose identity or whereabouts are unknown. Okay. In any action where the defendant, Okay. In any action where the defendant, okay, is designated as an unknown owner or the like, or whenever his or her whereabouts are unknown and cannot be ascertained by diligent inquiry, okay, within 90 calendar days from the commencement of the action, okay, service may by leave of court be effected upon him or her by publication in a newspaper of general circulation. Okay. And in such places and for such time as the court may order. Dito sa Section 16, may isang magandang kaso na dinicide yung Supreme Court. Okay. Now, Santos versus PNOC, GR number 170943, September 23, 2008. Ano bang nangyari dyan sa kaso ni Santos versus PNOC? Okay, PNOC Exploration filed a complaint for sum of money against Santos Jr. before the Regional Trial Court of Pasig. Okay, for collection of sum of money representing Santos's unpaid balance of the car loan advanced to him by PNOC when he was still a member of its board of directors. Okay. Now, personal service of summons could not be effected because Santos could not be located in his last known address, despite earnest efforts to do so. So what did PNOC do? Filed a motion in court and requested the court to allow it to serve the summons by publication. At ganun nga ang nangyari. Granted. Okay. Siyempre, nagkaroon ng judgment by default against Santos. Okay. Ngayon, pinestyon ngayon ni Santos pagdating doon sa CA that the proceedings and the judgment should be considered null and void. Why? Because this is an action in personam. And the submission of Santos before the Supreme Court was, dahil action in personam to, then the court can validly acquire jurisdiction over the person of the defendant only through personal service of summons or substituted service, hindi through publication. Tama ba si Santos? Did the court acquire jurisdiction over Santos? Supreme Court said yes. Okay. Petitioner invokes the distinction between an action in rem, okay, an action in rem and an action in personam, and claims that substituted service may be availed of only in actions in rem. Okay. Petitioner is wrong according to the Supreme Court. The in rem, in personam distinction was significant under the rules prior to the 1997 rules because it was silent as to the kind of action to which the rule was applicable. Because of this silence, the court limited the application of the old rule to rem actions only. This has been changed according to the Supreme Court. The present rule expressly states that it applies in any action where the defendant is designated as an unknown owner or the like, or whenever his whereabouts are unknown and cannot be ascertained by diligent inquiry. Thus, it now applies to any action, whether in personam, in rem, or quasi in rem. Notice that the rules, however, do not require the affidavit of complementary service be executed by the clerk of court. While the trial court ordinarily does the mailing of copies of its orders and processes, the duty to make the complementary service by registered mail is imposed on the party who resorts to service by publication. Moreover, even assuming that the service of summons was defective, the trial court acquired jurisdiction of the person of the petitioner, Santos, because of his voluntary appearance in the court. Okay, now this case of PNOC versus Santos is very important, especially in relation to Section 16. Because in the phrase, no, in any action, kahit nga daw yan in rem, quasi in rem, or in personam, basta ang defendant's identity is unknown, his whereabouts are unknown, you can serve it summons through publication, pursuant to Section 16. Okay, now, we go to Section 17. Okay. In Section 17, extraterritorial service, when the defendant does not reside and is not found in the Philippines. Wala dito si defendant dahil hindi siya dito nakatira at hindi dito nakikita si defendant sa Pilipinas. And the action affects the personal status of the plaintiff or relates to or the subject of which is property within the Philippines in which the defendant has or claims a real or interest, actual or contingent, on in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein, or the property of the defendant has been attached within the Philippines. Service may by leave of court be effected out of the Philippines by personal service or as provided for international conventions in which the Philippines is a party, or by general circulation in such places and for such time as the court may order, in which case a copy of the summons order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Any order granting such leave shall specify a reasonable time which shall not be less than 60 calendar days after notice within which the defendant must answer. Ito yung tinatawag nating extraterritorial service. When is extraterritorial service proper? It is proper when the defendant does not reside in the Philippines and is not found in the Philippines. And the case is either one of the four. One, it affects the personal status of the plaintiff. Okay? Petition for annulment of marriage. Number two, relates to or the subject of which is property within the Philippines in which the defendant has or claims a lien or interest, actual or contingent. Number three, it is the relief in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein. C, and D, or the property of the defendant has been attached within the Philippines. Okay. Para hindi natin makakalimutan, you know, the common denominator actually of B, C, and D, the last three, it's about a property of which the defendant has an interest. And then the first one is action affects the personal status of the plaintiff. But this one will only apply, as I said, if the defendant does not reside in the Philippines and is not found in the Philippines. Now, if those concur, okay, in any of those instances, the service of summons may by leave of court. This time you have to ask the court's permission to effect service of summons either through personal service, okay. Number two, as provided for in international conventions to which the Philippines is a party. Three, by publication in a newspaper of general circulation in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Period of time to file an answer, 60 calendar days after notice within which the defendant must answer. Okay. May isa akong kaso na alala. Sinabi lang na court publish, no? Pero walang registered mail na pinadala. Okay? Valid ba daw yung service? Sabi ng Supreme Court, yes. Kasi it will fall under the court. In any other manner, the court may deem sufficient. Okay. Now, Section 18. Okay. It's very short, so we read it first. Okay. Section 18, residents temporarily outside of the Philippines. Okay. Now, when any action is commenced against a defendant who ordinarily resides within the Philippines, but who is temporarily out of it, service may, by leave of court, be also effected out of the Philippines under the preceding section. Ano ba yung residence? What do we mean by residence? That is the place where the person named in the summons is living at the time when the service is made, even though he may be temporarily out of the country at the time. Okay? And that is the case of Montefalcon versus Vasquez. Okay. Maganda yung kaso niya Montefalcon. Yung husband dyan is seafarer. Okay? Dito talaga siya nakatira sa Pilipinas, pero nung panahon yun, tinawag siya para bumalik magtrabaho ulit sa barko. So nakatira talaga siya dito, tinawag siya, bumalik ngayon siya sa barko. So wala siya sa Pilipinas. And then the wife filed a petition for declaration of nullity of marriage. Pagkatapos nun, yung sheriff sinerve dun sa substituted service, okay, iniwan dun sa isang kamag-anak kung saan siya talagang nakatira. So the issue there is, did the court acquire jurisdiction over the person of the husband when at the time of the service of the summons, wala na yung husband, nasa barko na? Sabi ng Supreme Court, yes. Okay. Why? Okay. If you read Section 16, okay, of Rule 14, which is the current rule, no, which is actually Section 18 now, in the proposed 2019 rules. If you read it, okay, the section uses the words may and also. When any action is commenced against a defendant ordinarily resides within the Philippines, but who is temporarily out of service may, by leave of court, be also effected. Yung gamit na word na may and also, therefore, is not mandatory. Okay, yun daw sinasabi sa Supreme Court. Hindi mandatory na by publication lamang. Other methods of service of summons allowed under the rules may also be available by the serving officer on the defendant seaman. So ideally, the seaman must be personally served summons, but was personal service of summons practicable? Conversely, was substituted service of summons justified? Obviously, personal service of summons was not practicable because at the time, the defendant was temporarily outside of the Philippines already. To proceed with personal service on summons on the defendant seaman who went on overseas contract work would not only be impracticable and futile, it will also be absurd. Okay. Now, in this case, substituted service, okay, was valid and justified because previous attempts were made by the sheriffs to serve the summons but to no avail. Diligent efforts were evidently exerted in the conduct of the concerned sheriffs in the performance of their official duty. Also, the person who received the alias summons was of suitable age and discretion and a resident in the seaman's dwelling. Okay. Now, hindi ibig sabihin basta wala yung defendant, publication lang ang means. No, because precisely when you talk about Section 18 under the proposed rule, it means this is in addition to personal and substituted. Why? Because the defendant who is a temporary resident in the Philippines, who is a resident in the Philippines, is temporarily outside of the Philippines. Kaya makikita nyo yung distinction ng 17 and 18. Dito sa 17, yung extraterritorial service, yung defendant does not reside in the Philippines and is not found in the Philippines, then you do extraterritorial service of summons. Okay. But if the defendant is a resident of the Philippines but is temporarily outside of the Philippines, then you resort to Section 18. That's a distinction between the two. Okay. Now, we go Section 19. Any application to the court under this rule for leave to effect service in any manner for which leave of court is necessary shall be made by motion in writing, supported by an affidavit of the plaintiff of some person on his behalf setting forth the grounds for the application. So when you file a motion for leave of court to effect service of summons through publication, please do not forget your affidavit. Kailangan may magpapatunay, okay? Bakit dapat summons by publication ang pag-serve ng summons, okay? So when are the following instances where service of publication may be authorized with prior leave? Section 14, service upon foreign juridical entities not registered in the Philippines or has no resident agent but has transacted or is doing business in the Philippines. Number 2, Section 16, service upon defendant whose identity or whereabouts are unknown. Section 17, extraterritorial service. At Section 18, residents temporarily outside the Philippines. Okay. Now, Section 20, within 30 calendar days from the issuance of the summons by the clerk of court and receipt thereof, the sheriff or process server or person authorized by the court shall complete its service. Within 5 calendar days from service of the summons, the server shall file with the court and serve a copy of the return to the plaintiff's counsel personally by registered mail or by electronic means authorized by the court. Should substituted service have been effected, the return should state the following. Kaya makikita nyo kaagad kung improper yung service ng substituted service of summons. Kasi now, dapat ito ang nakalagay sa sheriff's return bag at dapat doon mo makita yung basis to effect service of summons through substituted means. Ano ang dapat nakalagay? Impossibility of prompt personal service within a period of 30 calendar days from issue and receipt of summons. The date and time of 3 attempts on at least 2 different dates to cause personal service and the details of the inquiries made to locate the defendant residing thereat. 3, the name of the persons at least 18 years of age and of sufficient discretion residing thereat, name of the competent person in charge of the defendant's office or regular place of business, or name of the officer of the association, okay, or condominium corporation or its chief security officer in charge of the community or building where the defendant may be found. Which incidentally, again, is based on a Supreme Court case, di ba? Ayaw papasukin sa isang posh village, okay? Ayaw papasukin, nalaman sheriff, sabi nung security court, ay, sandali ho, tatawagan ho namin yung si Mr. So-and-so. Tapos sabi ni Mr., ay, sorry, hindi ho kayo pwedeng pumasok, okay? Kasi sabi ng may-ari, hindi kayo papapasukin. So anong gagawin ni sheriff? Matapos siyang sabihin sa security guard na isi-serve niya yung summon kay Mr. So-and-so. Ang gagawin ni sheriff, hahanapin niya na ngayon yung either the officers of the homeowners association or kung sa condominium naman yung officers ng condominium association or yung chief ng security guard, doon niya ibigay yung summons. Kasi ayaw siyang papasukin Okay. Ngayon, pag lahat siya nakalagay, okay, doon sa sheriff's return, then the presumption of regularity will arise. Ngayon, kung incomplete yan, walang presumption of regularity dyan, di ba? Okay. Now, proof of service. The proof of service of someone shall be made in writing by the server and shall set forth the manner, place, and date of service, shall specify any papers which have been served with the process, and the name of the person who received the same, and shall be sworn to when made by a person other than a sheriff of his or her deputy. If summons was served by electronic mail, a printout of said email with a copy of the summons as served and the affidavit of the person mailing shall constitute as proof of service. Section 22. If the service has been made by publication, paano mo mapuprove na it was served by publication? Get the affidavit of the publisher, the editor, business, or advertising manager. Okay, to which the affidavit, a copy of the publication attached and by an affidavit showing the deposit of a copy of the summons and order for publication in the post office, postage prepaid, directed to the defendant by registered mail to his or her last known address. Okay. In Section 23, okay, the defendant's voluntary appearance in the action shall be equivalent to service of summons. The inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Okay. Please remember, okay, that once you ask for affirmative relief, you are deemed to have submitted to the jurisdiction of the court. And that's the case of Interlink Movie House versus CA. What are the examples of, you asking affirmative relief? Motion for extension of time to file answer. Motion for reconsideration. Motion to set aside order of default, motion to lift order of default, or a motion for, let's say, motion for recon, motion for new trial, voluntary and submission to the trial court's jurisdiction. Okay. And always remember, and this I said is very important, a motion, that the court failed to acquire jurisdiction over the person of the defendant cannot be a ground to sustain to support rather a motion to dismiss. The rules now require that you have to what? Raise it by way of affirmative defense. Is that clear? Well, I hope it's clear. Okay, Section 15. Motion. Okay, unang-una sa motion, kalimutan na natin yung Sections 4 and 5. Okay, anong ibig ko sabihin kalimutan natin yung Sections 4 and 5? Sections 4 and 5, which require, the movant to provide their a notice of hearing, to state when, the day, and the time when the motion will be heard, hindi na yan, wala na yan. Okay? Hindi na yan requirement in sections 4 and 5. Okay. Okay, so yun, no? So ano muna ba yung motion? It's an application for relief other than by a pleading. Okay. Look at your section 2. Malaking pagbabago kasi itong motions in section 2. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct the matter be heard wholly or partly on oral testimony or depositions. Okay. So there are now two kinds of motions as recognized by the rules, no? In writing or oral. Okay. Ngayon, if in the course of the trial, sabihin kunwari, Your Honor, may I request for a continuance because of lack of material time. Naghihiring ka, tapos biglang sabi ng plaintiff, for lack of material time, Your Honor, may I request that the hearing be for a continuance. Bago mag-rule si judge, tatanungin niya yung kabila, anong masasabi mo? And then the court now will make a ruling right then and there. Okay. Now, if a motion, on the other hand, is based on facts that are facts not appearing on the record, the court may require submission of affidavits or depositions. Okay. And the court may require oral testimony or depositions. Okay. Look at your section 4. Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious. Okay. Dito sa section 4, this is the first time where we have non-litigious motions. Okay. Yan yung amendment. So meron na tayong dalawang klaseng motions, not only as to the form, but as to the substance. As to the substance, we have non-litigious and litigious. What are non-litigious motions? Okay, as ruled in the case of Baganos versus Postanosas. Non-litigious motions are motions which the court may act on without prejudicing the rights of the adverse party. Okay. This motion, okay. And what are the examples according to the court? Yan, nakalista. Motions for the issuance of alias summons. Motions for extension of time to file answer. Motion for postponement. Motion for the issuance of writ of execution. Motion for the issuance of alias writ of execution. Motion for the issuance of writ of possession. Motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and other similar motions. Okay. Before I go to the next paragraph, let me just comment on these motions. Huh? Okay. These motions, in the first place, shall not be set for hearing. Ayun yung sunod na paragraph. And shall be resolved by the court within 5 calendar days from receipt of the said non-litigious motion. Okay. Now, as I said, okay, notice as an example ng non-litigious motion, motion for the issuance of an alias summons. Bakit ka hihingi ng alias summons? Na-return yung summons at served, nasira o nawala. So you ask for a motion for the issuance of an alias summons. Motion for extension of time to file answer. This motion for extension to file answer, notice under Section 11, Rule 11, a defendant under meritorious circumstances may only be granted an additional period of not more than 30 calendar days to file an answer. Isang beses lang time, one time, big time, extension. A defendant is only allowed to file one motion for extension of time to file an answer. Okay. Anong pangalawa? Motion for postponement. You can file a motion for postponement, but under Section 2, Rule 30, which we will discuss later, of the 2019 rules, okay, The party who caused the postponement is warned and will be warned that the presentation of its evidence must still be terminated on the remaining dates previously agreed upon. Hindi ka porke binigyan ng court o pinayagan ka ni court i-postpone, may additional or may kapalit na date para ibigay sa'yo. Hindi pwedeng i-extend yung period na pinag-usapan. Okay. Motion for the issuance of a writ of execution. Okay. I just would like to comment here for the motion of issuance of writ of execution. I will agree that it might be a non-litigious motion if the writ of execution prayed for is a matter of right. Okay. Remember that once a judgment becomes final, the prevailing party is entitled to the writ of execution as a matter of right, and the issuance thereof is the court's ministerial duty compellable by mandamus. In fact, it has been fittingly said that execution is the fruit and the end of the suit and is very applicable to the life of the law. That's the case of Mindanao Terminal and Brokerage Service versus CA. But what if the motion is a motion for execution pending appeal? Hindi naman siguradong ano yan. What you call this? Non-litigious. It should be considered as litigious because in the first place, the movant has the duty to show good cause. At saka yung kabila, dapat magbigyan ng opportunity naman na i-contest yun, di ba? Okay. Now, motion for execution of an alias writ of execution. And na-issue na yung writ of execution, na-return lang unserved. So, pwede kang humingi ng alias kung naibalik na. Okay. Okay. Number 2. Motion for issuance of a writ of possession. Okay. My comment on this. A writ of possession is a writ of execution employed to enforce a judgment to recover the possession, okay, of land. Okay. It commands the sheriff to enter the land and give possession of it to the person entitled under the judgment. A writ of possession may be issued in the following instances. In land registration cases under Section 17 of Act 496, in judicial foreclosure, provided that the debtor is in possession of the mortgage realty and no person, not a party to the foreclosure suit, had intervened. In an extrajudicial foreclosure of real estate mortgage under Section 7 of Act 3135, and number 4, in execution sales, okay? And that's the last paragraph of Section 33, Rule 39 of the Rules of Court. And this is based on the case of Spouses Reyes versus Spouses Chum, a 2017 case. Now, after the expiration of the period to redeem and no redemption was made, the purchaser as the confirmed owner has the absolute right to possess the land, and the issuance of the writ of possession becomes a ministerial duty of the court upon proper application and proof of title. Okay. That's the case of Gatuslav versus Yanson. Okay. Pero pagka may ibang tao na nakatira doon at nagpo-possess ng land, adverse to the judgment of obligor, okay, or the owner of the property, di ba? Hindi yan ministerial ang issuance ng writ of possession. Okay. Now, another example of a non-litigious motion will be your motion for issuance of an order directing the sheriff to execute the final certificate of sale and other similar motions. Okay. Now, may I just go back to this example, this one example of non-litigious motion, which is a motion for the issuance of a writ of execution, which is 1, 2, 3, the fourth example. No? Does it mean, therefore, that, you know, the writ will just issue and will, paano kunwari talagang nabayaran mo na yung utang? Okay? Nabayaran mo na yung utang, pagtatapos noon ay nag-file pa ng motion for issuance of writ of execution si judgment obligee. Okay? Are you not entitled to be heard on the matter? I think, you know, you can still file your comment or your opposition there too. Or, kung ang writ na issue, di mag-file ka ng motion to quash. Oo. Hindi pa rin nawawala yung karapatan mo i-contest, no? Ang ano lang dito is, kung talagang hindi mo nabayaran at talagang final and executory na yung judgment, then the writ of execution will issue as a matter of right. So as I said, if it's a non-litigious motion, the judge will not set it for hearing. You will not set it for hearing. The judge will not set it for, the court will not calendar it for hearing. The court will resolve it within 5 days from receipt of the said motion. But remember, any motion you file, you have to furnish the other party a copy of the said motion and then file the original in court. Ha? Miski na sabihin mong non-litigious motion yan. Okay, Section 6, and this is very important. The notice of hearing on litigious motion discretionary. The court may, in the exercise of its discretion, and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the date and time and date of the hearing. And this is the reason why I said earlier, the current practice now where we put notice of hearing, tapos yung address, tapos greetings. Okay, please be advised that the foregoing motion shall be heard on this date, at this time, or at any time convenient to the court's calendar or for the consideration of the court. Something to that, and then you sign. Wala na yun. Pag litigious motion siya, who will set it for hearing? It is the court, and the court may, in the exercise of this discretion, hindi automatic. Pag nakita lang na court, dapat i-hear to in its discretion. And if it deems it necessary for its resolution, will set the hearing on a Friday because your motion day is always, our motion day is always a Friday. And then it will send a notice of hearing addressed to all the parties concerned and shall specify the time and date of the hearing. Kaya, miski na hindi natin isi-set yan, so sa mga nagpo-practice, wag nating punuin yung ating Friday. Kasi pag nag-file tayo ng motion at sinabi ng court, ay gusto ko itong i-hit, isi-set niya yun sa Friday. Okay. Section 7. So wala na yung 3-day notice rule in effect. Wala na rin yun. Okay. Section 7. Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5B hereof. Okay? Now, kung ang mangyayari dito is the motion, any motion, whether it's litigious or non-litigious, okay? Motion, whether litigious or non-litigious, you have to serve it to the other party and then file it in court. Section 8, and this is the basis of what I said earlier, except for motions requiring immediate action where the court decides to conduct hearing on litigious motion, the same shall be set on a Friday. Okay. Now, yung omnibus motion, hindi pa rin yan nawawala. Okay? Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Now, the omnibus motion rule embodied in Section 8, Rule 15, in relation to Section 1, Rule 9, demands that all available objections be included in a party's motion. Otherwise, said objection shall be deemed waived. And the only grounds that the court could take cognizance of, even if not pleaded in said motion, are lack of jurisdiction over the subject matter, existence of another action pending between the same parties for the same cause, barred by prior judgment and statute of limitations. And the basis is Philippine Shell versus Romars International Gases Corp. Now, what is the purpose of the omnibus motion rule? It requires the movant to raise all available exceptions in a single opportunity to avoid multiple piecemeal objections. But to apply the statutory norm of omnibus motion rule, the objections must have been available to the party at the time the motion was filed. PH Credit Corp versus CA. Section 10, no substantial change. Section 11, no substantial change. Okay. Now, this is the more important one because this is an innovation. Okay. Okay. Section 12, prohibited motions. The following motion shall not be allowed. Okay. The following motion shall not be allowed. There is now such a thing as prohibited motions. Ang may prohibited motions tayo, prohibited pleadings, nakikita natin yan sa prohibited pleadings, no? Nakikita natin yan sa summary judgment o kaya motion, rule, small claims, prohibited pleadings, at saka rules on summary procedure, prohibited pleadings. Ngayon, may prohibited motions. The following motions shall not be allowed. First, motion to dismiss except on the following grounds: that the court has no jurisdiction over the subject matter of the claim, that there is another action pending between the same parties for the same cause, and that the cause of action is barred by prior judgment or by statute of limitation. Okay. Ano pa? Motion to hear affirmative defenses. Motion for reconsideration of the court's action on affirmative defenses. Motion to suspend proceedings without temporary restraining order or injunction issued by a higher court. Motion for extension of time to file pleadings, affidavits to any other papers except a motion for extension of time to file an answer as provided by Section 11. Motion for postponement intended for delay except if it's based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall at all times be accompanied by the original official receipt from the office of the clerk of court evidencing payment of the postponement fee, Section 21D, Rule 141, to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless, okay, may bayan. Okay, now, let me now discuss each and every prohibited motions and relate it with the others. Okay. Okay, prohibited motion. Okay, the first one. The new provision on prohibited motions, okay, stresses the underlying principle of the amendments, that is to make the disposition of every action and proceeding more just, speedy, and inexpensive as to prevent delay and to decongest the court. Okay. General rule, motion to dismiss not allowed, except if the motion to dismiss is grounded on this apat na sikat: lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription claims or statute of limitations. Now, kindly note under Section 1, Rule 9 of the 2019 rules, the four grounds are grounds that may even cause the dismissal of the complaint motu proprio. Now, kakaiba nga lang itong prescription na ground. Bakit ko sinabing kakaiba yung prescription na ground? If the ground is prescription, okay, you can raise it in a motion to dismiss, okay? Now, if the issue of prescription, however, all these grounds you can also raise in by way of affirmative defenses. But if the issue of prescription is one that involves a full-blown trial, okay, the court now may require presentation of evidence. And I think that's the reason why when it comes now, if you raise it by way of affirmative defense, the court may set it for hearing, actually, for clarificatory hearing if the court deems it proper to have a hearing set on that matter. Okay. Laches is not a ground, okay, for a motion to dismiss, because laches must be raised as an affirmative defense and not in a motion to dismiss. This is because the elements of laches must be proven positively. Laches is evidentiary in nature, a fact that cannot be established by mere allegations. Said issue must be resolved through presentation of evidence, and that's the case of Sanchez versus Sanchez, a 2013 case. Okay. Okay, now, again, before I leave that issue on motion to dismiss, okay, if you raise this four in an affirmative defense, okay, and the court denies those affirmative defenses based on the four, okay, what will happen? Okay, you cannot file a motion for reconsideration against the order denying that affirmative defense. You cannot even You cannot even make it a subject matter of a petition for certiorari, mandamus, or prohibition. But if you raise this for in a motion to dismiss, okay, there is no rule that bars you from filing a motion for reconsideration if that motion to dismiss is denied. And there is no rule that prohibits that the order denying the motion to dismiss and the order denying the motion for reconsideration be made subject of a Rule 65 petition. Okay. 3. Because of the repeal of Rule 16, okay, because of the repeal of Rule 16, when you file that motion to dismiss grounded on any of the four, and the motion is denied, what is the period of time within which to file an answer? Kasi remember, doon sa Rule 16, sinabi dyan, okay, that you have the remaining period but not less than 5 days within which to file the said answer. But because of the repeal of Rule 16, what will happen? Okay? Then the remaining period should be that the period within which to file an answer should be the remaining period. Okay? Kung nakuha mo yung summons June 1, okay? And then you have 30 days within which to file an answer. Pagkatapos final mo, let's say June 11, okay? 30 minus 11, yun na yung period nyo within which to file an answer. Okay. Okay, there is no need for you to file a motion to hear affirmative defenses. Okay, it is now prohibited pleading because precisely under Rule 16 of the current rules, okay, you really have to file a motion to hear affirmative defenses. Okay, and it will be treated as if a timely motion to dismiss was filed. But here, because you raise it by way of affirmative defenses, independent affirmative defense mo, the court will act on it, you need not file a motion to hear affirmative defenses anymore. Okay? Motion for reconsideration of the court's order or court's action on the affirmative defense, lalo na pag denial, you cannot file a motion for recon. Motion to suspend proceedings. Okay. Totoo, tama naman to, you don't file a motion, you don't suspend the proceedings below if, let's say, an interlocutory order was raised via certiorari. Okay? Because unless the higher court issues, let's say, an injunctive relief like a PRO or WPI, the proceedings below will not be abated or suspended. But let us not forget the ruling of the Supreme Court in the case of Eternal Gardens Memorial Park, which was reiterated in the case of Trajano versus Uniwide Sales. And ano ba yung ruling na yon? That is the principle of judicial courtesy. The principle of judicial courtesy applies only if there is a strong probability that the issues before the higher court would be rendered moot and moribund as a result of the proceedings or continuation of the proceedings in the lower court. That principle will therefore allow the lower court, notwithstanding the non-issuance of a TRO or WPI, to stop out of judicial courtesy. But this is an exception rather than the rule. Okay, now, motion for extension of time. Okay, I just would like to stress that the motion for extension of time to file pleadings, affidavits, or any other court submission, that's the general rule. The only exception is a motion for extension of time to file an answer. And you can only do it once. Motion for extension, okay, but I have a question lang, no? How about judicial affidavits? Sa judicial affidavit rule, AM number 12-8-8SC, okay, nahando sa JA rule, you can ask for an extension of time. Ito dito sa Rule 12, miski yung JA, hindi ka na pwede mag-ask for extension of time. So how will we reconcile the two? Okay? Impliedly repealed ba to ng provision ng Rule 12? It would appear. Okay? Motion for postponement. Okay. Motion for postponement intended to delay except if it's based on acts of God, force majeure, or physical inability will not be allowed. Okay. But even if, let's say, it is based on acts of God, physical inability, or force majeure, at grinant yung motion to postpone mo, you must finish the presentation of your evidence based on the schedule as agreed upon during the pre-trial conference, which we will discuss later. Okay. Okay. Now, Section 13. Okay. Subject to the right of appeal, an order granting a motion to dismiss, okay, or an affirmative defense that the cause of action is barred by a prior judgment or by statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, okay, or the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action. If you cannot refile it, then your only remedy is appeal. Okay. Just by way of recall, the difference between a dismissal with prejudice and one with prejudice is that the former, the one with dismissal with prejudice, it bars the refiling of the complaint. Whereas if the dismissal is without prejudice, then the same can be refiled. And that's the case of DBP versus Scarpio. Okay. When the law permits, a dismissal with prejudice is subject to the right of appeal. Okay. Now, as I said, Rule 16, deleted yan. Pero miski na-delete yung Rule 16, yung provisions na yan, na makikita mo sa iba't ibang parte ng 2019 rules, no? And even if it was deleted, ang rules natin, 15, walang 16, 17. There was no renumbering. So 15, 16, parang elevator. 12, 14, walang 13. Okay. Now, 17. Dismissal upon notice by plaintiff was not changed, Section 1. Okay, was not changed. But let me just discuss Section 1. I will not read the provision anymore because the provision under Section 1, Rule 17, was not at all changed. A complaint may be dismissed as a matter of right anytime before the service of an answer or a motion for summary judgment. What marks the loss by the plaintiff of the right to cause the dismissal of the action by mere notice is not the filing of the defendant's answer, okay, with the court, either personal or by mail, but the service on the plaintiff of said answer or of a motion for summary judgment. This is clear from the language of the rule. Okay, so that's one. Okay, number two. Okay. Notwithstanding that the notice of dismissal may be filed as a matter of right, the plaintiff must wait for the confirmatory order of the court. Otherwise, it may be construed as an act of disrespect or discourtesy, since plaintiff should await the court's action on their notice of withdrawal of the petition. And that's a case of Executive Secretary Burr versus Gordon. The dismissal will no longer be a matter of right if the plaintiff who was once dismissed in a court of competent jurisdiction an action based on or including in the same claim. But in the case of Ching versus Cheng, the provision on the two dismissal rule will not apply if the prior dismissal was done at the instance of the defendant. Dapat yung dismissal na yan both at the instance of the defendant, the plaintiff rather. Okay, Section 2. Okay, Section 2. Again, the change here is basically, okay, let me just read it because there's a change. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff's instance, save upon approval of the court and upon such terms and conditions that the court deems proper. Okay? If a counterclaim has been pleaded by defendant prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion, he or she manifests that he or her preference to have or her counterclaim resolved in the same action, unless otherwise specified in the order. A dismissal under the paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. Okay, let me discuss this Section 2. Okay, and this is a very recent case of Bly versus Bana. It's a 2018 case. The second sentence of the provision, okay, yung if a counterclaim has been pleaded by the defendant prior to the service upon him of the plaintiff's motion for dismissal, the rule is that the dismissal shall be limited only to the complaint. Commentaries on the subject elucidate that instead of an action, what will be dismissed is the complaint. So a dismissal of an action is different from a dismissal of the complaint. For this reason, since a complaint and not the action is dismissed, the defendant, in spite of said dismissal, may still prosecute his counterclaim in the same action. So na-dismiss yung complaint, but the defendant can prosecute in the same action his counterclaim, whether the counterclaim is permissive or compulsory. However, as stated in paragraph 2, if the defendant wants to prosecute his counterclaim in the same action, he is required to file a manifestation in court within 15 days from notice of the said motion. Ngayon, kung hindi siya mag-file ng motion, lumagpas yung 15 days, then his counterclaim, okay, his counterclaim may be prosecuted in a separate action, Bly versus Bana. Bakit ganon? Now, as explained by Justice Regulado in his treatise on the matter, under this revised section where the plaintiffs move for the dismissal of the complaint to which a counterclaim has been interposed, the dismissal shall be limited only to the complaint. Such dismissal shall be without prejudice to the right of the defendant to either prosecute his counterclaim in a separate action or to have the same result in the same action. Should he resolve to prosecute it in a different court, okay? Or he does not have to file a manifestation. But if he wants to prosecute it in the same case, file that manifestation and you're given a period of 15 days. Bakit kailangan mong i-file yan within the 15-day period? Because after 15 days na na-dismiss na yung court action, technically the court no longer has any authority to try the case kasi the judgment has already attained finality. So dapat mo yun i-file within the 15-day period. Okay, now, again, the case of Bly versus Bana. Okay. Now, in the case of now the third section, okay, section 3, okay. If for section 3, dismissal due to fault of plaintiff, if for no justifiable cause the plaintiff fails to appear on the date of the presentation of his or her evidence in chief on the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the defendant's own motion without prejudice to the right of the defendant to prosecute his or her counterclaim in the same action or in a separate action. This dismissal shall have the effect of an adjudication upon the merits unless otherwise declared by the court. Again, by way of recall, lalo na dun sa kumuha na ng civil procedure. If the defendant or if the plaintiff did not appear during defendant's presentation of his evidence, the defendant cannot file a motion, okay, to have the complaint dismissed. Why? Because na-prosecute na siya ng plaintiff. At most, ang magiging effect lang yan if the plaintiff does not appear during the presentation of defendant's evidence, the right of the plaintiff to object to question will all be deemed waived. Okay. Pangalawa, okay, dito sa rule na nagsasabi na, okay, if you fail to comply with the rules or order of the court, complaint will be dismissed with prejudice because you'll be considered a disobedient party. But remember, there are two exceptions to the rule, okay, as we have discussed before. The first exception to the rule is if the court orders you to implead a necessary party, you do not implead a necessary party, ang hindi yan madidismiss yung complaint. Magkakaroon lang yan ng waiver, okay? Waiver, okay? To go against the necessary party. Pangalawa, kung hindi ma-serve yung summons, okay? And then the court orders you to cause the service of summons and through other, in accordance with the means allowed under the rules of court, hindi mo yan ginawa, it will be dismissed, but it will not be with prejudice. Okay. Pangatlo, okay. Pagdating sa Section 3, pareho ng Section 2, you can prosecute in the same action or in a separate action, right? Your counterclaim, whether it's permissive or compulsory. But the difference is, bakit dun sa Section 3 may 15 days you are required to notify the court whether you're going to prosecute it, okay, in the same case or in a separate case. Okay? You're given a period of 15 days para i-notify yung court. But sa Section 3, wala yung 15-day period na yan. Kasi, sino ba ang nag-file ng motion doon sa Section 2? Yung plaintiff. Kaya ikaw, kailangan mo sabihin sa court. Itong Section 3, ikaw ang nag-file ng motion, sabihin mo na sa court kung anong gusto mong gawin doon sa iyong counterclaim. Okay? Whether you want to prosecute it in the same case or in a different case. Section 4 is the same. Okay. Rule 18. When conducted, after the last responsive pleading has been served and filed, the branch clerk of court shall issue within 5 calendar days, okay, from filing a notice of pretrial, which shall be set not later than 60 calendar days from the filing of the last responsive pleading. Okay. Now, pretrial, as I said, a pretrial is a procedural device intended, okay, to clarify and limit the basic issues between the parties. It's supposed to pave the way for a less cluttered trial and resolution of the case. It's meant to abbreviate, simplify, and expedite the trial. Therefore, there is a need for strict adherence to the rules, okay? And that's pursuant to the case of Chua versus Spouses Cheng. When Section 1, okay, states responsive pleading, okay, when after the last responsive pleading, ano ba yung last responsive pleading? It is not necessarily the answer. Remember, under the rules, it may be the reply. If the complaining party wants, not the complaint, but the defendant, okay, no wait, the complaining party, right, wants to deny the due execution of an actionable document which was attached, okay, and made part of the answer, okay, or if the answer, okay, or if the answer is, let's say, if the reply is based on an actionable document, okay, then it may be a rejoinder if the defendant would like to deny the due execution and authenticity of an actionable document that was attached to the reply. Okay. Issues must be joined before the pretrial can be scheduled. Issues are joined when all the parties have pleaded the respective theories and the terms of the dispute are plain before the court. And that's Rosetta versus Lim. Under Section 1, it is the duty of the court, or clerk of court rather, to schedule the pre-trial conference. Okay. Now, Section 2, the pre-trial is mandatory and shall be terminated promptly. Okay. Now, okay, let me just read this. This one is quite long. Section 2, the pre-trial is mandatory and should be terminated promptly. The court shall consider the possibility of an amicable settlement or of a submission to alternative modes of dispute resolution, the simplification of the issues, the possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof, the limitation of the number and identification of witnesses and the setting of trial dates, the advisability of preliminary reference to issues to a commissioner, the propriety of rendering judgment on the pleadings or summary judgment or dismissing the action should a valid ground therefore be found to exist. Now, and this is important, the requirement for parties to mark the respective evidence, if not yet marked, in the judicial affidavits of their witnesses. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. Okay? Number 3, manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. Reserve evidence not available at the pre-trial but only in the following manner. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witnesses. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be made if not made in the manner described. Such other matters as may aid in the prompt disposition of the action. Failure without just cause of a party and counsel to appear during the pre-trial despite notice shall result in the waiver of objections to the faithfulness of the reproductions marked or the genuineness and execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pre-trial, which shall have the following format, which is the format is attached to the rules. Okay. Let me just discuss this, especially to those who are already practicing. Okay. Okay. Section 2 is really very important. Okay. Why? Okay. Now, okay, for the students, we all know that admissions made in a stipulation of facts at pre-trial dispenses now presentation of evidence because they are considered as judicial admissions. And judicial admissions require no proof, okay? Eastern Shipping Lines. Now, the veracity of judicial admissions requires no further proof and may be controverted only upon a clear showing that no such admission was made or, okay, or no such admission was made or it was made through palpable mistake. So admissions of parties during pre-trial as embodied in the pre-trial order are binding and conclusive upon the person making them. And that's a case of Cuenco versus Talisay Tourist Sports Complex. Okay. Now, di babalikan natin yung diniscuss natin last time. Pag nag-file tayo ng complaint, pag nag-file tayo ng answer, dapat na handun na kasama as a rule yung judicial affidavits, documentary evidence mo, and even the object evidence. Dapat nakalakip yan. Okay. Ngayon, pagka ngayon tayo pupunta during pre-trial, anong mangyayari? Nire-refer tayo for preliminary conference. Doon sa preliminary conference, magpapakitaan na kayo ng mga dokumento for purposes of marking and comparing. Okay. You show to the other party the photocopy and the original of the document, and then you ask the other party to compare it so that you can have the photocopy marked in evidence. Okay. Now, just by way of reminder, there is a significant distinction between identification of documentary evidence and formal offer of evidence. When you speak of identification of documentary evidence, that is done in the course of the pre-trial, that is done during the trial, and is accompanied by marking of evidence as an exhibit. While, okay, formal offer of evidence is done only when the party is about to rest its case. The mere fact that a particular document is identified and marked as an exhibit does not mean that it has already been offered as part of the evidence. It must be emphasized that any evidence which a party desires to submit for consideration of the court must be formally offered by the party, otherwise it can be excluded and rejected. That's the case of heirs of Pasag versus spouses Parocha. Okay. Itong reservation ang pinaka-importante. Okay. Diba, sa ngayon, pag when we go to court, sometimes we just say, Your Honor, may we reserve the presentation of additional documentary or testimonial evidence should, as circumstances may warrant. Okay. Okay na yun, may reservation ka. Pero ngayon, ang reservation hindi na pwedeng ganun. Why? Because it's very clear here under this section, reservation of evidence is now expressly allowed subject to the following conditions. Number one, for testimonial evidence by giving the name or position and the nature of the testimony and the proposed witnesses. For documentary evidence and other object evidence by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described. Hindi na yung catch-all, no? Ngayon, kailangan mong sabihin sa korte kung ano yung ebidensyang nire-reserve mo. Okay? Kung hindi mo sabihin at i-describe yan, hindi ka napapayagan. Okay? consequences of the failure of without just cause to appear during the pretrial despite due notice, the failure of the plaintiff and counsel to appear without valid cause shall cause the dismissal of the action. The dismissal shall be with prejudice unless otherwise ordered by the court, Section 5. Now, if it's on the part of the defendant and counsel, the defendant will not be declared in default. Bakit? May naman siyang answer. But, okay, he will suffer the consequences of default, such as what? The plaintiff now may be allowed to present his or her evidence ex parte. And now, and this time, it's very clear when the plaintiff must present his evidence ex parte. Within 10 calendar days from the termination of the pretrial. So that the court now will render judgment on the basis of the evidence presented. If you do not also appear during the pretrial, defendant, you do not, plaintiff, you do not appear, shall result in a waiver of any objections to the faithfulness of the reproduction mark or their genuineness and due execution. Hindi ka umappear sa pretrial, okay? Yung plaintiff cannot question it anymore. Okay, the failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. Unless, of course, I think you make a reservation. Okay. Now, let's go to notice of pretrial. Okay, the notice of pretrial shall include the dates respectively set for, and this is now the amendment. Kasama na ang schedule ng pretrial, ang court annex mediation, at saka yung JDR. Okay. And which means, ngayon sa Rule 18, it's very clear that JDR and mediation are part of the proceedings or the pretrial conference. Okay. Now, non-appearance in any of the foregoing settings, you don't appear during JDR, you don't appear during court annex mediation, shall be deemed as non-appearance at pretrial and shall merit the same sanctions as Section 5, which is good because some people, they do not attend mediation, okay? Kasi mediation lang. No. Ngayon, pwede kang ma-dismiss yung complaint mo. Pwedeng mag-evidence to be presented by the plaintiff. The defendant may be able to present his evidence ex parte against the plaintiff. If plaintiff failed, okay, to appear during mediation or judicial dispute resolution. Okay? Now, the non-appearance of a party and counsel may only be excused for acts of God, force majeure, or duly substantiated physical inability, and that is Section 4. Okay. Once a representative appears, that representative must be fully authorized to appear during the pretrial, mediation, and the JDR. Okay. Now, let me just, okay, your pretrial brief, very important, okay? It is mandatory and you still have to submit it at least 3 calendar days before the date of the pretrial conference. Okay. Now, in the pretrial brief, okay, you should include a concise statement of the case and the reliefs prayed for, summary of the admitted facts and the proposed stipulations, the main factual and legal issues to be tried. Hindi lang issues, dapat yatiin mo. Factual, legal. The propriety of referring factual issues to the commissioner. The documents or other object evidence to be marked stating the purpose thereof, the names of the witnesses and the summary of the respective testimonies, and a brief statement of points of law and citation of authorities. Okay. Kung mapapansin ho nyo dyan, merong hindi na isama dyan. Kung yung dun sa dating Rule 18, di ba nakalagay the availment of modes of discovery. Ibig sabihin ba hindi na encourage yan? The answer is no. Encourage pa rin yan. Because even if that specific provision was not carried over to the 2019 rules, Section 7H of Rule 18 of the 2019 rules specifically requires that the provision of AM number 03-1-09 pretrial guidelines must still be followed. At dyan sa AM number 03-1-09, very clear in 1.2, resort to modes of, you will be ordered by the court precisely to avail of the modes of discovery. At ang importante din dyan sa incorporation of that AM administrative matter, we still follow, and the court can still require the parties to follow the one-day witness rule, okay, and the most important witness rule, okay? Now, okay, pre-trial order, okay. A pre-trial, okay, upon termination of the pre-trial, the court shall issue an order within 10 calendar days which shall recite in detail the matters taken up. Okay. So, ayun ang nalagay. A, okay, but may panibagong nilagay dito yung the case, it should be included in the pre-trial order. The case flow chart to be determined by the court which shall contain the different stages of the proceedings up to the promulgation of the decision and the use of time frames for each stage in setting the trial dates. You know what is so nice about this, okay? Para siyang game plan eh. Pero ang gagawa niyan yung court, okay? And that will be our guide, okay? Now, as I said, no? Also in the pre-trial order, it should state that there should be a statement that the one-day examination of witness rule and the most important witness rule shall be strictly followed, okay? Now, a statement, and this is important, okay? A statement that the court shall render judgment on the pleadings or summary judgment as the case may be. Anong ibig sabihin yan? The court can decide to submit the case on the basis of judgment on the pleadings or summary judgment motu proprio. The direct testimony of the witness for the plaintiff shall be in the form of JA after the identification of such affidavits and cross-examination. Postponement of presentation of the parties' witnesses at the scheduled date is prohibited, except if it's based on acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. Ilang beses na natin itong narinig at maririnig niyo pa yung pagdating natin sa Rule 30. Okay? It only goes to show the importance, the premium these rules have given to the principle na talaga dapat mabilis na ang proseso sa korte. No? Hindi ka pwede basta-basta mag-postpone. Okay. Now, let me just focus on this particular provision, okay, also in pre-trial conference. Section, give me 1 minute please, Section 8. After pre-trial and after issues are joined, the court shall refer the parties for mandatory court annex mediation. The period for court annex mediation shall not exceed 30 calendar days without further extension. Okay. Ngayon, pag hindi na settle dyan sa court annex mediation, pwede ka bang mag-invoke? Please, Your Honor, pwede ba kaming mag-JDR? Okay. And this is now the rule in JDR. Pursuant to Section 9, only if the judge of the court to which the case was originally raffled is convinced that settlement is still possible. So it is the call of the judge. If the judge thinks that, oh, may possibility pa to, o kaya talagang mabuti mag-settle to dahil magkakapatid ito, okay, then it will be referred to JDR. But unlike the current practice, no, if the case is to be referred to JDR, the case may be referred to another court for JDR. It is not the court that is to which the case was originally raffled. It is to another court. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days only. Not 30 days, but 15 calendar days from notice of failure of the court annexed mediation. If JDR trial before, okay, if the JDR fails, the case will go back to the original court and trial will proceed. Okay, now, Section 10, okay, Section 10, this is new, okay. Should there be no controverted facts or no more genuine issue as to any material fact or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 and Rule 35, motu proprio, include in the pre-trial order that the case shall be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda. In such case, judgment shall be rendered within 90 calendar days from termination of the pretrial. The order of the court to submit the case for judgment pursuant to this rule shall not be subject to appeal or certiorari. Anong ibig sabihin yan? If based on the stipulation, based on the papers already before the court, okay, sinabi ng court, wala nang issue to, no issue at all. I now decide that I will submit this for judgment on the pleadings. Or if the ostensible issues were unmasked to its very core, showing that the issues are what? Sham, fictitious, not even genuine at all, okay? Then the court now will decide, I will submit this case for decision based on summary judgment. That order submitting the case for judgment on the pleading, that order submitting the case for summary judgment will be included in the pretrial order. Now, the order of the court submitting it for summary judgment, the order of the court submitting it for summary judgment or judgment of the pleadings, hindi pa yun yung judgment. Okay? Technically, interlocutory order yon. And that's the reason why the court, okay, the order of the court to submit the case for judgment on the pleadings, summary judgment, it cannot be subject to appeal or even certiorari. Okay? Ito yung innovative dito ngayon, innovation rather, na the court during the pre-trial stage, based dun sa nakita niya, can make that decision now na I would submit this, okay, for judgment on the pleadings on motion for summary judgment or on the basis of summary judgment. Yung order ng court na yun, as I said, not subject to appeal kasi wala pa yung judgment di ba? Or certiorari, hindi mo yan ma-certiorari. Okay. So we're done with Rule 18.